in 14 districts in Uganda. And for purposes of the House, I will list the districts as Kasanda, Rampara, Bugwere, Nabiratuku, Chikube, Kwania, Kalenga, Kapelabyong, Kazo, Kitagwenda, Kalaki, Terego, Obongi, and Madiokolo. Madam Speaker, while processing the budget of this running financial year, government presented an envelope of 45 trillion, and through the budget committee, Parliament appropriated 47 billion for the procurement of equipment for these districts that were created 3 years ago. Ministry of Works went ahead and signed contracts for procurement based on the IPFs, but government through Ministry of Finance has declined or has not been able to release this money to the Ministry of Finance. These districts are suffering, and this is affecting service delivery and affecting the peasants, and also affecting the utilization of the road fund to those districts. Through you, Madam Speaker, and the House, I'm praying that Ministry of Finance releases the 47 billion that was appropriated by Parliament to the Ministry of Works to procure. Honorable Tamaguzi, you can give information.
Honorable Tamaguzi.
Madam Speaker, fun enough, even some districts which have managed to get those road equipments, when you look at the quality of their roads, it's actually wanting. A district like Nakaseka have ever gone there, and that's what is the purpose of the road equipments which government bought, yet all roads are in sorry state. So, Madam Speaker, I just wanted to remind my Honorable Kenya that as government, they should also find ways of monitoring most of the districts in Uganda. Why is it that they bought the road equipments, they are there, yet the roads are in sorry state? Thank you, Madam Speaker.
Thank you, my brother. Madam Speaker, the second prayer is that since from the corridors, the Minister of Finance is going to bring a supplementary budget, let it capture the 47 billion for the districts to be able to get the road equipment and improve on service delivery for the people.
Honourable members, obviously it was the plan of government that every district must have equipment to ensure that the roads are maintained. We had a set from China, another second set from Japan. These districts are created and they don't have the equipment. This is really a negation of the notion of service delivery. Can we know from the Minister of Finance what happened to the money that was appropriated for equipment for the new districts? Minister, are you in a position or you would need time? Another.
Madam Speaker, with your permission on the first question which the Honorable Cyrus raised about the 300 million grant from the World Bank. The one we know for the World Bank is meant to do roads. 130 million is meant to do Koboko Road, Koboko Yumbe Road. Then education, universal secondary will receive 50 million, and then energy expansion project will be 54 million, and you give 60 million. Digital enhancement 40 million. Then the fund that we're expecting for SAGE is 12 million from the Irish, the government of Ireland, and we are concluding the MOU in the next 3 weeks from now. So that's the status on the two grants that I understood you wanted to know. On the issue of appropriation for the road equipment, the money that we appropriated, I need to ask, we shall cross-check, Madam Speaker, with the Minister of Works, because to the best of my knowledge, we don't have any problem. We have not received any complaint from Minister of Works that we have not released the money. Maybe the issue is to do with procurement or something, but I'll cross-check and inform the House tomorrow.
Okay, please let us know so that we can assuage the fears of the people in those areas. Honorable Makmot, 2 minutes.
Thank you, Madam Speaker, for this opportunity. Madam Speaker, I rise on a matter of national importance. Madam Speaker, we have been dealing with what I term commercial, illegal charcoal burning and logging. And it is indicated now that Agago is the epicenter in the entire, actually, sub-region. This is a very organized trade where members are coming even from across the border to do this kind of trade in an isolated village in Adilang sub-county, Agago district. Madam Speaker, this is an area that needs intervention because the level of environmental degradation in this area, if you see the pictures, Madam Speaker, is despicable. And we've tried, but there's need for the relevant ministry to intervene with a view of stopping this illegal trade, and also seeking means of intervening in this area, maybe with promoting tree growing, among other things, to compensate for what has been done. Otherwise, it is gross, it is alarming, and it is raising a lot of concern. Thank you, Madam Speaker.
I don't see the Minister for Environment here, but the issue of environmental degradation is a serious one. Can we ask the Minister for Environment to establish a situation in Adilang sub-county in relation to the illegal logging of trees and give us a report within a fortnight? Thank you. Item 3.
Item number 3, laying of papers. Number 3.1 from the Ministry of Finance, Planning and Economic Development.
Minister of Finance.
Madam Speaker, it's a proposal by government to mobilize approximately Uganda shillings 130 million US dollars from the domestic market to finance the initial equity portion and historical costs for the East African crude oil pipeline. I beg to lay.
Members sent to the Committee of National Economy for perusal and report back. 3.2.
Item 3.2, laying of papers, Parliamentary Commissioner.
Commissioner Mwijuke.
Thank you so much, Right Honourable Speaker. The annual report for the year ended 30th June 2020, I beg to lay.
Now, members, to send the Public Accounts Committee, Commission, State Authorities, and State Enterprises for perusal and report back. Item 4.
Item number 4, Bill second reading, the Administration of Estates, Small Estates Special Provisions Bill 2019.
Minister of Justice.
Madam Speaker, I beg to move that the Administration of Estates, Small Estates Special Provisions Amendment Bill 2019 be read for a second time.
Is the motion seconded? Seconded. Justified.
Madam Speaker and honorable members, as you will recall, I introduced in this House on the 12th day of September 2019 the Administration of Estates, Small Estates Special Provisions Amendment Bill 2019 when it was read for the first time. The objects of the bill are to revise the monetary jurisdiction of the Magistrates' Court to conform to the Magistrates' Courts Act. B. To provide for the revocation of a grant of probate or letters of administration for want of jurisdiction. The salient features or the salient provisions in the bill are as follows. The bill makes provision for increasing the monetary jurisdiction of a magistrates court grade 1 from the maximum value of 50,000 shillings to the maximum value of 20 million shillings. The bill makes provision for increasing the monetary jurisdiction of the Chief Magistrates Court from the maximum value of 100,000 shillings to the maximum value of 50 million shillings. The bill also seeks to amend the Act to provide that probate or letters of administration may be revoked or annulled for want of jurisdiction. We have interacted with the Legal and Parliamentary Affairs Committee, with whom we have shared comments from interested parties as well as our own views. The committee also made comments and proposed amendments to the bill to which we shall respond. The government is also receptive of proposals intended to further improve the bill. Madam Speaker and honorable members, I beg to move that the bill entitled the Administration of Estates, Small Estates Special Provisions Amendment Bill 2019 be read for the second time.
Thank you very much, Minister. Can we now invite the report of the Committee, Legal and Parliamentary Affairs? The Chair, Committee on Legal. Or the Vice Chair? Honorable Kojo? Okay.
Thank you, Madam Speaker. This was supposed to be presented by Honorable Monica Amoding. I don't see her here. So I was proposing that we go on to the next one, the Administrator General's Amendment Bill, which I'm supposed to present. Thank you, Madam.
Oh, honorable members, the report is a report of the committee. Every member of the committee should be in a position to present. Were they chaired by different members?
The responsibilities were assigned to different members, each of whom took up their responsibility. Like you saw yesterday, Honorable Veronica and Honorable Jova presenting theirs. I can't tell. Maybe Honorable Asman has a solution.
Yes, Honorable Asmani.
Right Honorable Speaker, as Honorable Rakojo has observed, these are succession-related bills. They were 4 in number, so at the level of the committee, the chair assigned different responsibilities to different members, and I'm aware this responsibility was given to Honorable Amoding, but that should not in any way impede the work of this House. I have the report on my iPad, and if it pleases, I can proceed to read the report.
Please present the report, because it's a report of the committee.
Yes, it is.
Proceed.
Thank you, Right Honorable Speaker. This is a report of the Committee on Legal and Parliamentary Affairs on the administration of estates, small estates, Special Provisions Amendment Bill 2019. Right Honourable Speaker, I will not go into the introduction methodology, but I'll briefly read the object of the bill, which is to amend the Administration of Estates, Small Estates Special Provisions Amendment Bill to revise the monetary jurisdiction of the Magistrates' Courts to conform to the Magistrates' Courts Act and to provide for the revocation of probate or letters of administration for want of jurisdiction. Right Honourable Speaker, the administration of small estates is governed under the Administration of Estates, Small Estates Special Provisions Act 156, the Administrator General's Act Cap 157, and the Succession Act Cap 162. A small estate is an estate of a value prescribed in Section 2 of the Administration of Estates, Small Estates Special Provisions Act. Section 2 limits a small estate to an estate whose value does not exceed 100,000 shillings. The jurisdiction of grant of letters of administration or probate in small estates is the preserve of magistrate courts, wherein a magistrate grade 2 has jurisdiction over a small estate whose total value does not exceed 10,000 shillings. A magistrate grade 1 has jurisdiction over a small estate whose total value does not exceed 50,000 shillings. And the chief magistrate has jurisdiction over a small estate whose total value does not exceed 100,000 shillings. The Administration of Small Estates Special Provisions Act is therefore intended to ensure the just administration of all estates in Uganda, irrespective of their size. The Administration of Small Estates Special Provisions Act and the rules made thereunder ensure that small estates are administered with little modalities in order to reduce the cost of administering such estates, as well as ensuring that the beneficial interest in the estate is maintained. The process of applying for probate or letters of a small estate is simple, based on standardized forms prescribed in the Administration of Small Estates Special Provisions Act and the rules made thereunder, and can be undertaken without the need of a lawyer or any form of legal training. Priority for grant of letters or probate is given to the children of the deceased, the surviving spouse, the father or mother of the deceased, and other persons related to the deceased by full or half blood. The Administrator General may also be granted letters of administration of a small estate in two instances. The first instance is where the people to whom priority is granted do not apply for the grant. The other instance is where the Administrator General or an agent of the Administrator General, pursuant to Section 2, subsection 5 and Section 4, subsection 5 of the Administrator General's Act, takes over and administers the estate with or without grant made by court. Right Honourable Speaker, the need for the bill. The Administration of Estates, Small Estates Special Provisions Act, Cap 156, is the law that governs the administration and execution of small estates in Uganda. This act commenced on the 6th of June 1972, and due to passage of time, some aspects of it have become outdated, especially in light of the Constitution, government policies, emerging international best practices, and the legal environment. The committee notes that the object of the bill is to amend the Administration of Estates, Small Estates Special Provisions Amendment Bill 2019 to revise the monetary jurisdiction of magistrate courts to conform to the Magistrate Courts Act and to provide for the revocation of probate or letters of administration for want of jurisdiction. The committee notes that the amendment is premised on the need to expand the pecuniary jurisdiction of the magistrate court in granting or revoking letters and probate in small estates to align the jurisdiction with that granted to such courts under the Magistrates Courts Act, Cap 16. Furthermore, the committee observes that the values prescribed in Section 2 of the Administration of Estates, Small Estates Special Provisions Act are too low to be effectively administered in the current economic situation. The committee observes that under the law, a small estate is one that has a value of not more than 100,000 shillings. This value was significant at the time the law was enacted, but has with passage of time been eroded by inflation, making the provisions redundant and ineffective since the cost of obtaining profit or letters exceeds the value of estate as well as the beneficial interest in the estate. The committee further observes that since the provisions of Section 2 have been made redundant by passage of time, many estates have been wasted or unadministered owing to the cost of obtaining letters of administration or probate from the High Court being higher than the value or the beneficial interest of the estate. The committee takes cognizance of the Administrator General's Cause number 493 of 2003, wherein the deceased maintained shillings 200,000 as her bank balance with Bank of Baroda. When the Administrator General requested the bank to send the funds to him for transmission to the beneficiaries, the bank replied that the letters of administration had to be obtained before the funds could be sent. Since it was 200,000, the application had to be made to the High Court, and the Administrator General charges 200,000 to make the application. Given that all the funds were going to be consumed in the process, the beneficiaries abandoned the money in the bank. Therefore, the proposal to expand the values of small estates under the Administration of Estates, Small Estates Special Provisions Act is intended to bring services closer to the people, reduce the cost of obtaining letters or probate in estates whose values fall within their jurisdiction, ensure that the beneficiaries draw as much value from estate, and allow for the just and effective administration of estates of deceased persons irrespective of their value. Analysis, observations, findings, and recommendations. Right Honourable Speaker.
No, I don't think you need to.
Could I go straight to the recommendations?
Yes, go to the recommendations.
Okay. So the recommendations. It is the considered view of the committee, Right Honourable Speaker, that clause 1 is deleted with the jurisdiction that is redundant in light of section 14 and 15 of the Acts of Parliament Act Cap 2. The second recommendation, Right Honourable Speaker, is that clause 2 is adopted. The value of the estate should be expressed in currency points, and the currency point should be defined. This is intended to shield the value from being eroded by inflation. The committee also recommends that section 7, subsection 2 is deleted, and section 10 is amended to allow the application of the Succession Act to applications under the Administration of Small Estates Special Provisions Act. In light of the above, Right Honourable Speaker, the committee proposes that the Administration of Estates Small Estates Special Provisions Act is due for amendment as explained above. It is therefore the committee's recommendation that the bill is read for the second time and thus pass with the following amendments. We beg to pray and submit.
Thank you very much, Honorable Basalirwa, and the Committee of Legal and Parliamentary Affairs for another piece of work to improve the legislation in this area. Now, members, the report has been signed by the necessary minimum number. You are free to make your comments. No members, no one is interested in saying anything? Yes, Honorable Silas.
Right Honourable Speaker, This bill nearly has no difference with the one of yesterday. The difference is quite small. Yesterday, somebody was jumping up and down to think he should not continue hearing my opinion. But Madam Speaker, let me ask a question. The committee needs to support me and help me. We are using currency points to shield the shilling against inflation. What happens to the monetary value attached to the currency point? Because it's also exposed to inflation. For me, that was my issue. Issue number 2, how often do we revise the value of a currency point? How often? Thank you.
Now, of course, Honorable Gon, yes, you said that we talked about this matter, but you know, this one is now self-explanatory, because if an estate is, the limit of the jurisdiction of a magistrate grade 2 is 10,000 shillings. How much will be required to file a case for 10,000 shillings? Do you need a lawyer? How much will you pay the lawyer? In the case of 10,000, you know, the estate is 10,000 shillings. So that's really the reason why the government thinks we should do this in currency points, because they're easier to change. Now, an estate, you have just seen an example. The bank account has 200,000 shillings. The cost of the application by the administrator general is 200,000 shillings. So everything goes. The whole estate is gone. But maybe the mover can explain the other part, which Honorable Algon wanted to know. Minister? Any other comments, honourable members? No more comments on this bill? Yes, you can respond.
Right, Honourable Speaker, I just wanted to explain to Honourable Orgon that under the law revision, fines and other financial amounts in Criminal Matters Act 2009, Section 7, grants powers to the minister by a statutory instrument to review the currency points as and when deemed necessary. Secondly, for further clarity, this bill is brought in order to bring the law in line with the Magistrates Courts Act. The pecuniary jurisdiction, or the money set in the old law, is 100,000 and 10,000 shillings. And yet a grade 1 magistrate's pecuniary jurisdiction is 20 million shillings. A chief magistrate is 50 million shillings. So we needed to amend this law in order to bring it in line with the law setting the financial jurisdiction for the magistrates courts. That's all.
Okay, honourable members, in the absence of any other comments, I put the question that the administration of estates, small estates, special provisions amendment bill 2019 be read for a second time. Those in favour say aye, the contrary no. Committee stage.
The administration of estates, small estates, special provisions bill 2019, bills committee stage.
Okay. Come. This bill you brought is not the one. I need this one. But maybe I'm going to borrow from the clerk.
Clause 1.
Members, put the question that clause 1 be deleted. Those in favor say aye, the contrary no. Ayes have it.
Clause 2.
Now I think there is proposal for a new clause. Honorable Sarira.
Chair, clause 1.
New clause.
Oh, yeah, there is a proposal to insert a new clause immediately after clause 1. And the proposal, Chair, is amendment of Section 1 of the Principal Act. The Administration of Small Estates Special Provisions Act, in this act referred to as the Principal Act, is amended in Section 1, inserting the following definition immediately before paragraph A. A currency point has value assigned to it in the schedule to this act. The justification is to insert a schedule on currency points. 2, to express all values in the currency points as is adopted in all other laws. And 3, to shield the values prescribed in the act from inflation.
Honourable members, the question is that a new clause be inserted as proposed. Those in favour say aye, the contrary no. Ayes have it.
New clause.
Put the question that the new clause do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 2.
Clause 2, Honourable Chair.
Chair, clause 2, we propose an amendment to read as follows. An amendment to Section 2 of the Principal Act. Clause 2 of the bill is amended. A paragraph B, by substituting for the words 20 million shillings, the words 1,000 currency points. And in paragraph C, by substituting the words 15 million, the words 2,500 currency points. The justification is to shield the values in clause 2 from being eroded by inflation. They should be expressed in currency points. And through expressing them in currency points makes their upward or downward amendments easy, since the minister usually has power to amend clauses of the act.
Now, members, the question is that clause 2 be amended as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 2 as amended.
Question is that clause 2 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it. You have a new clause, Honourable Chair.
Chair, we propose to insert a new clause in the bill, and that is after clause 2, which should read as follows. Insertion of new section 5A in the Principal Act, and we propose that the Principal Act is amended by inserting immediately after section 5 the following. 5A, grant of certificate for micro estates. Where it appears to the court that the gross value of the assets or property of a deceased person is in the form of cash, cash in the bank, death gratuity, household assets, vehicles, or another movable property, and does not exceed 1,000 currency points, court may, on the application of a surviving spouse or lineal descendant, grant that person a certificate entitling him or her to administer the estate of the deceased person and to pay out of it any debts or charges, and to pay, remit, deliver any surplus to any person entitled to it according to law, as may be directed by court. And section 4 shall apply to all applications made under this section.
I'm lost a bit.
not different. Because what does you have?
Can you start again, Honorable Chair? On the new clause.
Chair, we propose to insert a new clause in the bill, and that new clause is immediately after clause 2. And we propose to amend the Principal Act by inserting immediately after section 5 the following: that where it appears to the court that the gross value of the assets or property of a deceased person is in the form of cash, cash in the bank, death gratuity, house, hold assets, vehicles, or any other movable property, and does not exceed 1,000 currency points, the court may, on the application of a surviving spouse or lineal descendant, grant to that person a certificate entitling him or her to administer the estate of the deceased person and to pay out of it any debts or charges, and to pay, remit, or deliver any surplus to any person entitled to it according to law, or as may be directed by the court. And that section 3 shall, with the necessary modifications, apply to an application made to court under this section.
Madam Speaker.
Yes. Honorable.
The proposed insertion, the proposed clause is rejected. Right, Honorable Speaker, there are two types of grants under the existing law: a grant of probate and a grant of letters of administration. The proposed amendment is introducing a grant outside the known grants of letters of administration and letters of probate that are referred to in Cap 156 of the Succession Act. The proposed amendment, while introducing a third type of grant, does not set out the procedure for applying for the grant, and it creates a third type of grant that is not necessary. Secondly, the proposed grant for micro estates means that the property in issue, for example, household property, vehicle, and so forth, will have the value, will have to be valued first in order for one to determine whether they are not an estate that falls within the ambit of the micro estate. This will bring an added expense to the estate and make the process of applying for administration of a micro estate more expensive and complex. Right, Honorable Speaker, the proposed third grant would be a superficial appendage that is not necessary, because the two known grants, letters of administration and letters of probate, would still cater even for the estate they intend to cure. I beg to submit.
Honorable Chair, what's the rationale for your proposal?
Chair, we don't have a very strong opinion on that. We are trying to cater for micro estates, but we can concede on that, Chair.
Okay. Okay, honour members, the proposed to insert a new clause has been abandoned, and we had dealt already with the amendment in clause 2. So I think we just, now what about the schedule? The schedule.
Schedule.
Chair, we propose to insert a new schedule in the Principal Act in light of our earlier proposal of introducing currency point. So the schedule is pursuant to Section 1, and we're saying a currency point is equivalent to 20,000 shillings. The justification is that the insertion of Section 5A is to allow the ease administration of an estate of a deceased person where it does not exceed Uganda shillings 20. No,
Honourable Chair, you can't refer to 5A because we have abandoned it.
Chair, it is actually a consequential amendment arising from amendment of Section 2.
Okay. Now, members, the question is that a schedule be inserted as proposed. Those in favour say aye. The contrary, no. Ayes have it.
New schedule.
Put the question that the new schedule be part of the bill. Those in favour say aye. The contrary, no. Ayes have it.
Title.
Put the question, the title of the bill. The title do stand part of the bill. Those in favour say aye. The contrary, no. Ayes have it.
Motion for the House to resume.
No, Minister.
Right Honourable Speaker, I move that the House do resume and the Committee of the whole House report thereto.
Now, members, the question is that the House do resume and the Committee of the whole House do report thereto. Those in favour say aye. The contrary, no. Ayes have it.
Report from the Committee of the whole House.
Honourable Minister.
Right Honourable Speaker, I beg to report that the Committee of the whole House has considered a bill entitled The Administration of Estates, Small Estates Special Provisions Bill 2019 and passed it as follows. Clause 1, amended. Clause 2,
deleted. Clause 1, deleted.
Clause 1, deleted, sorry. Clause 2, amended. Insertion of a new clause immediately after Clause 1. Insertion of a new schedule on currency points.
Motion for adoption.
Motion for adoption of the report of the Committee of the whole House.
I beg to move that the report of the Committee of the whole House is adopted.
Now, members, the question is that the report of the Committee of the whole House be adopted. Those in favor say aye, the contrary no. Let's have it.
Bill's third reading, the Administration of Estates, Small Estates, Special Provisions, Bill 2019.
I beg to move that a bill entitled The Administration of Estates, Small Estates, Special Provisions, Bill 2019 be read a third time and it do pass.
Now, members, the question is that the Administration of Estates, Small Estates, Special Provisions Bill 2019 be read for a third time and do pass. Those in favor say aye, the contrary no. Ayes have it.
A bill for an act, the Administration of Estates, Small Estates, Special Provisions Act 2021.
Title settled and bill passes. Item 5.
Bill second reading. The Administrator General's Amendment Bill 2019.
Right Honourable Speaker, I want to thank you for providing us the opportunity to accomplish one of the laws and our succession laws, which really has been long overdue. We want to thank the committee chairperson and the members of the committee and the learned Attorney General for the cooperation we received throughout this process. But more importantly, Right Honourable Speaker, for the members of Parliament who have been with us, especially at this time when attendance is a challenge, we want to thank you, and we hope that the other bills that are coming, please be available, because Right Honourable Speaker, succession is a very critical issue in this country, and you can only confront it when you get there. So I think these are bills where all of us should take very keen interest, and they should not be left to, as some people are saying, those are your bills, those are for lawyers. One time in life, we will all die, we will be succeeded. So it's important that we take interest in this matter, and I want to call upon our colleagues to be around and we take interest in this bill, and to you, Right Honourable Speaker, for the guidance and the time you have accorded us as a committee. I thank you.
Thank you very much, Minister.
Right Honourable Speaker, I want to thank you for your tireless efforts. Some people consider these bills insignificant. They may see them as small, but they don't know the kind of impact they have. And it is our duty to review all laws, to look at the recommendations, and with your sitting in that chair, you guide so that we produce a law for posterity, for the future of Uganda. Just like Asuman has said, these laws are very important. We should not consider them insignificant. They have come with the recommendations right from the Law Reform Commission. It is our duty to bring them in tandem with our current situation. And with your good guidance, we've been able to do that. I thank you so much.
Minister and the Committee on Legal and Parliamentary Affairs, and members of the House for the work done. Let's go to item 5.
Item number 5, the Administrator General's Amendment Bill 2019.
Minister of Justice.
Madam Speaker, I beg to move that the Administrator General's Amendment Bill 2019 be read a second time.
So motion seconded? Is the motion seconded? Yes. Several members have seconded. Proceed.
Madam Speaker and honorable members, as you will recall, I introduced in this House on the 12th day of December 2019 the Administrator General's Amendment Bill 2019 when it was read for the first time. The objects of the bill are as follows: to align the Administrator General's Act to Article 32 of affirmative, that in brackets, affirmative action in favor of marginalized groups, and Article 33, that is the rights of women, of the Constitution of the Republic of Uganda. To increase the jurisdiction of the Administrator General from 20,000 shillings to 50 million shillings. To provide for the requirement for notice of application for letters of administration by widowers and widows to be given to the Administrator General before applying to the High Court for a grant to the High Court to administer the deceased spouse's estate. To provide a penalty for intermeddling with estates of a deceased person, and to exempt the bank accounts of the Administrator General from being attached in proceedings, that is garnishi. The salient provisions of the bill are as follows. The bill makes provision for increasing the value of the estate over which the Administrator General and agents appointed under the delegated powers of the Administrator General may administer an estate in form of cash in the bank, or death gratuity, estates of only household assets, estates with only household assets, vehicles, or other movable property, summarily without letters of administration, from 20,000 shillings to 50 million shillings. Requirement of widows and widowers and their attorneys to give notice of application for letters of administration to the Administrator General before applying to the High Court for letters of administration. To give the Administrator General power to assume the administration of those estates where it is urgently necessary for the preservation of the estates where intermeddling is reported. To exempt the bank accounts of the Administrator General from being attached in proceedings. We have interacted with the Legal and Parliamentary Affairs Committee, with whom we have shared comments from interested parties as well as our own views. The committee also made comments and proposed amendments to the bill, which shall be responded to. Government is also receptive of proposals intended to further improve this bill. Madam Speaker and honorable members, I beg to move that the bill entitled the Administrator General's Amendment Bill 2019 be now read for a second time.
Thank you very much, Honourable Minister. Can I now invite the Chair of Legal and Parliamentary to present the committee report?
Madam Speaker, I stand here to present the report of the Legal and Parliamentary Affairs Committee on the Administrator General's Amendment Bill 2019. Prior thereto, I beg to lay the report of the committee on table. Madam Speaker, I further request to be allowed to read an abridged version of the report, since it was uploaded on the report was uploaded on the iPads, and members, I believe, have looked through.
Yes, proceed.
Thank you very much. Thank you very much, Right Honourable Speaker, for giving me this opportunity. Madam Speaker, I seek your indulgence. Pardon me. Right Honourable Speaker and colleagues, on the 12th August 2019, Government introduced in Parliament the Administrator General's Amendment Bill 219. The bill was accordingly referred to the Committee on Legal and Parliamentary Affairs pursuant to Rule 128 of the Rules of Procedure of Parliament. The bill mainly seeks to amend the Administrator General's Act, Cap 157, to revise the mandate of the Administrator General's Office by prescribing the estates that can be administered by the Administrator General without recourse to courts of law. B, scale upwards the penalties for offences committed under the Act. C, align the Administrator General's Act to Article 32 on affirmative action in favour of marginalised groups and Article 33 on rights of women of the Constitution of the Republic of Uganda. D, to increase the jurisdiction of the Administrator General from 20,000 to 15 million shillings. E, provide for the requirement for notice of application for letters of administration by widowers or widows to be given to the Administrator General before applying to the High Court for grant to administer their deceased spouses' estates. F, provide a penalty for intermeddling in estates of deceased persons. And G, exempt the bank accounts of Administrator General from attachment proceedings. Right Honourable Speaker, the Office of the Administrator General is established under the Administrator General's Act, Cap 157, as a corporation so with perpetual succession. The Administrator General oversees administration of estates of deceased persons, of declared persons, and in some situations administers estates of deceased persons through the Public Trustees Act as a public trustee. The Administrator General's Act grants the Administrator General the right to apply to court to administer the estate of a deceased person where A deceased person appoints the Administrator General as the sole probate, B, the deceased did not appoint an administrator or probate, C, a person appointed in the will of a deceased predecedes the deceased person or renounces probate of the will. D, letters or probate have not been obtained within 2 months from the death of the deceased person, or E, where the deceased person died without leaving a valid will. Owing to the broad functions of the Administrator General, Section 4 of the Administrator General's Act empowers Administrator General to be notified of the death of a deceased person and may apply for letters or probate. The Administrator General is also granted priority to the grant of letters of administration over a creditor, legatee, other than a universal legatee, and a friend of the deceased person. The need for the bill. The committee notes that the Administrator General's Act is in need of amendment to bring it in line with the Constitution, changes to government policy, and to deal with inflation that has eroded the Administrator General's jurisdiction. The committee notes that the Administrator General's Act was commenced on 15th August 1933 and has not been amended since to bring it in line with the Constitution, changes to government policy, and to do with inflation that has eroded Administrator General's jurisdiction. For instance, the Administrator General can administer estates ranking from a value of 20,000 shillings to a value of 15 million shillings in the form of cash in bank, or death gratuity, or estates with only household assets, vehicles, and other movable property with a court order. These are really small estates for which the cost of obtaining letters of administration or probate might exhaust the estate, making the administration of no value to the beneficiaries. Further, the committee notes that the Administrator General is empowered to delegate to an agent the administration of estates of a value not exceeding 2,000 Uganda shillings. The committee finds that these estates are really small, don't reflect the current economic situation, and unreasonably burden the Administrator General with the administration of micro estates where the cost of administration exceeds the value of the estate. Similarly, the penalties prescribed in the Administrator General's Act are not deterrent enough and have affected the administration of estates by the Administrator General. For instance, Section 12 of the Succession Act prescribes a penalty of Uganda shillings 200 for intermeddling in the estate of a deceased person, a matter that affects the effectiveness of the provision. This clearly shows the Act is due for amendment. Madam Speaker, allow me to comment on some salient areas the bill proposes to amend. The first is the short title and commencement. The bill proposes in Clause 1 to provide for the short title and commencement of the bill once enacted into law. Maybe on that one, just to say that it's the same as it has been in the other laws. So just to go on to say that it is actually evident that Clause 1 is redundant, because when we look at the Acts of Parliament Act and its requirements, like we've been doing in the other bills that have come before this, it provides for the citation of the Act, which is already provided for in Section 15 of the Acts of Parliament Act, as well as prescribing the commencement of the Act on publication, yet the same is already prescribed in Section 14 of the Acts of Parliament Act. The committee therefore recommends that Clause 1 is deleted with the justification that it is redundant in light of Sections 14 and 15 of the Act of Parliament Act Cap 2. Interpretation. The bill proposes to amend Section 1 of the Principal Act by making changes to the definition of the word assets or property, by inserting a new paragraph defining currency points, and by repealing the definition of the word next of kin. The committee is in support of this proposal since it is intended to not only modernize the Principal Act but also to bring it in line with the Succession Act. For example, the committee notes that the deletion of the words next of kin is intended to specifically align the terminology used in the Principal Act with the Succession Act, wherein the persons who may benefit from the estate of deceased persons are not referred to as the next of kin, but are referred to as persons who are entitled to share in the estate of a deceased person. In light of the above, the committee recommends for the adoption of Clause 2 of the bill. 3. Power to administer estates by agents appointed by the Administrator General or the Minister. Clause 3 of the bill proposes to amend in Section 2.5 by changing the value for which an agent of the Administrator General can exercise summary powers of the Administrator General from 2,000 shillings to 15 million, where property in cash, cash in bank, or death gratuity, or where the property is in form of household assets, vehicles, or any other movable property. Section 2.5 of the Administrator General's Act is to the effect that the Administrator General may, at his or her discretion, delegate to an agent any or all of the powers and duties conferred or imposed upon him or her by this Act. But in default of any directions by the Administrator General to the contrary, every agent appointed by the Minister may, in the administration of estates of persons dying intestate and leaving property within his or her area, which doesn't appear to exceed 2,000 shillings in gross value, exercise all summary powers of the Administrator General under this Act. The above provision empowers an agent appointed by the Minister or delegated powers by the Administrator General to exercise the summary powers of the Administrator General over estates of a value not exceeding Uganda shillings 2,000. The committee notes that the effect of the amendment proposed in Clause 3 is to expand the jurisdiction of agents appointed by the Minister to summarily exercise the powers of the Administrator General and administer estates of a value of Uganda shillings 15 million if property is in the form of cash, cash in bank, or death gratuity, or where property is in the form of household assets, vehicles, or any other movable property. The committee notes that whereas there is need to amend this provision in light of inflationary pressures that has affected the monetary jurisdiction of the agents appointed by the Minister, which has rendered this provision redundant. The provision is ambiguous and may have the effect of granting the agents unlimited jurisdiction over estates that would ordinarily be the preserve of the Administrator General. We should be concerned that the failure to specify the maximum limit of the estate that can be administered by agents will mean that Administrator General will have delegated all the powers granted to it by Parliament, contrary to one of the pivotal principles of administrative law, which states that a delegate cannot delegate. And it might create confusion as to which estates are to be administered by agents and those to be administered by an Administrator General, thereby creating forum shopping and perpetrating corruption, abuse of power, and conflict between the agents, the Administrator General, and the beneficiaries in those estates. In light of the above, the committee recommends that Clause 3 is amended by limiting the jurisdiction of agents appointed by the Minister to only small estates, being estates in form of property in form of cash, cash in the bank, death gratuity, household assets, vehicles, or any other movable property not exceeding 50 million shillings. Secondly, expressing the maximum value in currency points in order to cater for inflationary pressures that will erode the pecuniary jurisdiction of the agents appointed by the Minister if the same is expressed in Uganda shillings. Thirdly, granting the agents appointed by the Minister or the Administrator General jurisdiction over small estates, since this will bring services closer to the people, reduce the cost of obtaining letters or probate in estates whose values fall within their jurisdiction, ensure that the beneficiaries draw as much value from the estate and allow for the just and effective administration of estates of deceased persons, irrespective of their value, without eroding the beneficial interest of the estates. The fourth point is power to administer estates by the Administrator General. Right Honourable Speaker, the bill proposes in Clause 4 to amend Section 4 of the Principal Act by expanding the pecuniary jurisdiction of the Administrator General from 20,000 Uganda shillings to 15 million Uganda shillings. The committee observes that Section 4.5 of the Principal Act empowers the Administrator General to, without any letters of administration or other formal proceedings or notice, take possession of the estate of a value not exceeding 20,000 shillings and realize the same by sale or otherwise, and pay thereout any debts or charges, and pay, remit or deliver any surplus to such person as may appear to him or her to be entitled to it. We note that Section 4.5 of the Administrator General's Act has, with the passage of time, become ineffective
due to the effect of inflation on the pecuniary jurisdiction prescribed in the Act, and is therefore in need of amendment. The absurdity of this provision is reflected in Administrator General's Clause 493 of 2003. This is the one Honorable Basalira was reading, where the deceased had 200,000 in the bank, and the cost of administration also came to 200,000. So since all the funds were going to be consumed, the beneficiaries just abandoned the money in the bank. So the provision is ambiguous and may have the effect of granting agents unlimited jurisdiction over all estates in Uganda. Further, in granting the Administrator General jurisdiction over property which is in the form of household assets, vehicles, or any other movable property without prescribing a maximum value of the estate for which Administrator General may exercise summary powers granted under the Act will cause confusion, since a person will not know the estates for which Administrator General may administer without recourse of going to court. The committee is also further concerned that provision is not shielded from inflationary pressures and changes in the value of the Uganda shilling, and observes that the proposal to express that value of the estate for which the agent can administer in Uganda shillings exposes the jurisdiction of agents to changes in the value of the Uganda shilling, which is affected by inflation and loses value over time. The committee prefers that in order to shield the jurisdiction of agents from inflation, the value should be expressed in currency points, since currency points are not affected by changes in the value of the Uganda shilling or inflation. The committee is also further concerned that there appears to be a disconnect between the bill and the amendments proposed in the Administration of Estates, Small Estate Special Provisions Act. The committee therefore does not understand how the value of Uganda 15 million shillings was arrived at, yet the smallest estate in Uganda is between 10,000 shillings to 50 million shillings. The committee notes that since the intention of the amendment to Section 2.5 of the Administrator General's Act is to ensure estates of a lower value are administered directly by Administrator General in order to reduce the cost of administration, reduce wastage and diminishing value of those estates, and to bring services closer to the people, the estates that may be administered directly by the Administrator General should be small estates as prescribed in the Small Estates Special Provisions Act. In that regard, therefore, the committee is of the considered opinion that since this provision grants Administrator General the right to take over and administer estates without recourse to courts, this should be limited to small estates whose value does not justify recourse to court. The committee therefore recommends that Clause 4 is amended by A, limiting the jurisdiction of Administrator General to summary administration of an estate without recourse to court, to small estates being estates whose value in form of property, in form of cash, cash in bank, death gratuity, household assets, vehicles, and any other movable property does not exceeding 50 million shillings. B, expressing the maximum value in currency points in order to cater for inflationary pressures that will erode pecuniary jurisdiction of the agents appointed by the minister if the same is expressed in Uganda shillings. 5, obligation of the surviving spouse to inform Administrator General. Madam Speaker, Clause 5 proposes to amend Section 5 of the Principal Act by deleting the words "or the widower or widow of the deceased, or his or her attorney duly authorized in writing, authorizing that person to administer the estate of a deceased person." The proposed amendment will have the effect of excluding the surviving spouse and his or her attorney from the categories of people who do not have to inform the Administrator General before applying for letters of administration. This would mean that a surviving spouse would have to obtain a certificate of no objection from the Administrator General before administering or executing the estate of his or her deceased spouse. The committee rejects this proposal since it does not consider the proprietary rights of the surviving spouse who is entitled to share in the property of the deceased spouse. The committee notes that during marriage, a spouse acquires a right to share in property that constitutes matrimonial property, and spouses are entitled to share, but anything to the contrary, equal in the property. The proposal in the bill reverses that right upon the death of the spouse by subjecting the surviving spouse's property rights to the whims of the Administrator General. Since the surviving spouse has proprietary rights in the estate of his or her deceased spouse, it would be unfair for the surviving spouse to seek the authorization of the Administrator General to administer his or her own property. The committee therefore rejects the amendment proposed in clause 5 and recommends for the deletion of the word widows or widowers in section 5.1 of the Administrator General's Act and replaces it with surviving spouse. 6. Intermeddling in the estate of a deceased person. Madam Speaker, the bill proposes in clause 7 to amend section 11 of the Principal Act to allow the Administrator General to, insofar as may be urgently necessary for the preservation of the property of a deceased person who dies intestate or who leaves a will, or where a person causes to be moved or otherwise intermeddles with property of a deceased person, administer the estate of the deceased person until court grants letters or probate. The bill also proposes to expand the penalty for intermeddling in the estate of the deceased person from imprisonment for 3 months to imprisonment for 3 years. The committee has examined the amendment to proposed section 11 of the Principal Act and is in support of the amendment. The committee notes that incidents of intermeddling in estates of deceased persons have been increasing over time and have been a source of wastage of the estate and the depleting of the beneficial interests of the estate. The committee notes that whereas intermeddling in the estate of deceased persons is prohibited under the Succession Act and the Administrator General's Act, there are no mechanisms that can immediately assist an estate or beneficiary free itself from intermeddling by a person. The proposal by the bill is intended to provide a mechanism through which an estate or beneficiary can free itself from the act of intermeddling by allowing the Administrator General the right to take over and preserve the estate until letters or probate are granted. Currently, the penalty prescribed for intermeddling in an estate is so low at Uganda shillings 200 or imprisonment for a period of 3 months. This penalty is not deterrent enough, and this explains why the incidents of intermeddling in the estate of deceased persons are on the rise. However, the committee is concerned that the provision might not achieve the intended effect. For instance, the committee notes that intermeddling is not defined in the Administrator General's Act. The committee notes that the failure to define what amounts to intermeddling is a big drawback that will affect the effectiveness of the provision. The committee notes that since intermeddling provisions are intended to protect the estate of a deceased from unlawful interference, abuse, or wastage by persons without lawful authority, the actions of the Administrator General need to be limited in scope and time and restricted to actions that are essential for the preservation of the estate of a deceased person and not to allow the Administrator General the right to administer the estate of a deceased person without lawful authority. In light of the above, the committee recommends A, that the powers of the Administrator General should be limited to only preserving the estate rather than administering the estate of the deceased without lawful authority. B, that there should be a specific definition of what amounts to intermeddling. C, apart from Administrator General, a person should be empowered to apply to court to stop the intermeddling of any individual in the estate of a deceased person. D, a person who intermeddles in the estate of a deceased person to make good the loss caused to the estate. E, for uniformity, the provisions on intermeddling in the estate of a deceased person should be harmonized with those in the Succession Act. The 7th point is the sale and disposal of property by Administrator General. Clause 10 of the bill proposes to amend section 16 of the Principal Act by substituting the words, for the words next of kin, the words spouse, lineal descendants, and dependent relative. Section 16 of the Administrator General's Act is to the effect that the Administrator General may, subject to any wishes which may be expressed by next of kin of the deceased, dispose of the property of an estate under his or her administration, either wholly or in part, and either by public auction or private treaty, as he or she in his or her discretion may deem to be in the best interest of the estate. The bill proposes to amend the provision to require consultation of the spouse or lineal descendant rather than the next of kin. The committee examined the provision and is of the considered opinion that the amendment should be supported since it recognizes that essential people should be consulted by the Administrator General. Therefore, the committee recommends that Clause 10 is adopted, albeit with the following amendments. A, the disposal should be beneficial to the estate and the beneficiaries. B, the consent should be written. C, the disposal should be necessary to cater for the basic needs of the persons entitled to benefit under the estate. D, the disposal should recognize the proprietary rights of the surviving spouse. E, the Administrator General should account for the proceeds of the sale. F, the sale is subject to sections 26 and 36(6) of the Succession Act, which exempts the residential holding from the same. G, the sale is on market value terms. H, the disposal to be null and void if not carried out in a transparent manner. The committee also recommends that for completeness, Administrator General or an employee of the Administrator General should not sell to him or herself property belonging to an estate he or she is executing or administering. 8. Notification by gazette and newspaper of wide circulation. Clause 12 and 13 of the bill seek to amend Section 18 and 19 of the Principal Act by removing the gazette as one of the mediums through which the Administrator General may notify the creditors and others having claims against the estate to file and prove their claim against the estate. The Administrator General may now publish the notice in at least one newspaper of wide circulation in the area where the estate is situated, as well as using any other means of communication that may be appropriate. This provision should be supported since the gazette is not easily accessible to the general public compared to newspapers. Furthermore, it allows the Administrator General to utilize any other means of communication, including digital platforms as well as other electronic media, to make the notice. These modern forms of communication are easier, reach more masses than traditional media, and are accessible. The committee recommends that clause 12 and 13 are adopted, albeit with amendment, to ensure that the notices are made in a newspaper of wide national circulation in order to justify as many people as possible. 9. Court to appoint persons to receive minors' share. Right Honourable Speaker, the bill in clause 15 proposes to amend section 27 of the Principal Act by expressing the value of the share of a minor, which the Administrator General may, at his or her discretion, pay or transfer to the father or mother of the minor, or some other suitable person or the public trustee on behalf of the minor, in currency points rather than in shillings. The committee has examined the proposal and is in support of the amendment proposal since it shields the value from inflation. However, the amendment to section 27 does not go far enough since it maintains a provision that is no longer good in law in light of the amendments to the Children Act and the proposals made to the Succession Act as far as the holding of a child share is concerned. The committee notes that section 27 of the Administrator General's Act empowers the appointment of a child's father, mother, or any other person to receive the child share under the estate. The committee recommends for the adoption of the amendments proposed in clause 15. Committee further recommends that section 27 of the Administrator General's Act is amended to comply with the provisions of the Children Act and the amendments made to the Succession Act in this regard. 10. Attachment of Administrator General's bank accounts. Clause 17 of the bill proposes to amend section 35 by inserting a new subsection 2, requiring that the costs, damages, interest, and related litigation expenses in any suit against Administrator General are charged on the consolidated fund, as well as exempting from attachment and bank accounts of the Administrator General. The committee examined the proposal made in the bill and is of the considered opinion that this provision may be challenged for infringing Article 21 of the Constitution. The committee notes that Section 22 of the Administrator General's Act allows the taking of action against the Administrator General, and upon such action, court has issued orders for the attachment of the accounts of the Administrator General. In light of the above, the committee recommends that the proposal to exempt the accounts of the Administrator General from attachment is rejected, since it will be challenged for infringement of Article 21(1) on equality of all before the law. Further, the Administrator General considers opening individual accounts for individual estates he or she is administering so that all funds relating to an individual estate can be deposited thereon. And in case of attachment, it's only the relevant account that is affected and not the entire accounts of the Administrator Generals. 11. Disposal of insignificant balances. The bill proposes to delete section 37 of the Administrator General's Act, which relates to disposal of insignificant balances. That section is to the effect that after completion of the administration of an estate by the Administrator General or his or her agents, if the net balance for distribution among heirs abroad is less than 500 shillings, the Administrator General may distribute the balance amongst such persons as appear to be entitled to it and remit the amount so due by bank draft, registered money order, or postal order. The committee examined the proposed amendment and finds it to be misconceived and will create a lacuna in the law since the Administrator General will not be guided on how to transmit a person's share in the estate. Furthermore, the proposal will also create a lacuna in the law insofar as removing the distribution of the estate to persons who are outside the territorial jurisdiction of Uganda. In light of the above, the committee recommends that Section 37 should be retained in the Principal Act, albeit with amendments to enhance the threshold prescribed thereunder and to express the threshold, if any, in currency points, and to allow the transfer of such property to any person who is entitled to share in the estate. Lastly, harmonization with the Succession Act. The committee has examined the Administrator General's Act and found that it's not in harmony with the Succession Act in some instances. The committee notes, for example, that Section 20 of the Administrator General's Act is in conflict with the Succession Act, especially Sections 280, 281, 282, and 283 of the Succession Act. Section 24 provides to the effect that fees, charges, and reimbursements due to the Administrator General are to be the first charge on the estate after payment of funeral expenses and may be deducted from any monies received by the Administrator General in the course of administration. The above provision gives fees, charges, and reimbursement of the Administrator General first priority over all other expenses and fees incurred by the estate. The committee notes that Sections 280, 281, 282, 283 of the Succession Act guide on the priority of paying fees and charges and disbursement and requires that funeral expenses have priority, followed by the expenses of obtaining probate or letters of administration, followed by wages due for services rendered to the deceased within 3 months preceding his or her death by any laborer, artisan, or domestic servant, and thereafter the creditors are paid. Section 20 appears to be in conflict with the provisions of the Succession Act insofar as giving priority to expenses, fees, charges, and reimbursements due to the Administrator General over all other expenses and fees incurred by the estate. This disharmony needs to be remedied and rectified. The committee recommends that the Administrator General's Act should be harmonized with the Succession Act. In light of the above, the committee proposes that the Administrator General's Act is due for amendment and should be amended as proposed in the Administrator General's Amendment Bill 219. Conclusively, Right Honourable Speaker, the committee recommends that the Administrator General's Amendment Bill 219 is read the second time and do pass with amendments.
Thank you very much, Honourable Chair of the Legal and Parliamentary Affairs Committee and the members. Honourable members, the report, as you've heard, is quite interesting. It has been signed by the necessary minimum members. You are free to make comments. That's Honourable Kenneth. So, do minutes, please. Honourable Muganza. Yes, Honourable.
Thank you very much, Madam Speaker, and thank you, Chair, for the committee for the report that you have presented to the House. Madam Speaker, I have only one point to make, for which I seek clarification from government, where government is proposing that the accounts of the Administrator General should not be subject to attachment. I think this is really quite discriminatory and a preferential treatment to an entity of government, which can even encourage laziness and carelessness of a government body. When you look at cases involving the Administrator General, you find that actually it is the other parties who are usually in the weaker position that should be protected, and not the Administrator General. So I would want to know the justification as to why you would think that these accounts should be immune from being attached. And as the committee has said, Article 21, if for instance you are saying the Administrator General's account should not be subject to attachment, what about a situation where himself, the Administrator General herself, if I can use that, the entity is the one to be attaching the accounts of another? Are you saying Administrator General should also not be allowed to recover by way of attaching accounts of another? To To me, I think that this should not be acceptable, and in order to allow for prudence and frugal and being diligent workers of government, these accounts must actually be attached. It is only then that the Administrator General can actually be forced to do the work with extreme care and due diligence. Thank you.
Now, before I invite Honorable Namugaza, I'm on that same area. You know, I've been thinking, what are the sources of income of the Administrator General? My thinking is that the money they have is the money of the estates of the people of Uganda. So if it is my money and my father's money, my grandmother's money, why should it be attached for debts of the Administrator General? That's, I'm a bit, Honorable Namugaza.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I want to appreciate the committee, the good work they have done. Right Honourable, I support so much the committee, especially where it comes to the powers of the Administrator General being trimmed. As a person who works in the Ministry of Lands, Right Honourable, there are so many cases or issues where the Administrator General has intermeddled into the estates of the late, and to the extent that sometimes of the beneficiaries because of the gaps in the current laws, and which I consider to be too much powers which was given to this particular office. So I think, Right Honourable and colleagues, being that we have the Succession Act, which is very clear, I would feel like the Administrator General should be left with very limited powers, very limited, in fact, not even beyond meetings, because all the problems we are having as Minister of Lands, especially on the properties of the deceased, are coming from the Administrator General's office. To the extent, Right Honourable Speaker, that they can give letters of administration to several people. And we have always written to them, and they say, we issued this, we discovered the other one was the right person, we discovered the other one was also right, something which is not allowed. And when it comes to them withdrawing them, they don't even support. Even courts of law calls them and they deny. So, Right Honourable, this office was given too much power. In fact, we have acted too late. It would have been handled much earlier than yesterday to trim their power and remain with probably the committee is still leaving them with a lot of powers. For me, I think even chairing beyond the meetings is too much for them. Thank you.
Thank you. Honorable Kakoza.
Thank you, Right Honourable Speaker. I think due to the environment today, if all institutions need transparency and accountability, all sources which goes to these government agencies must be audited, and the Auditor General should give an opinion. So there is no way you can exempt the Attorney General and then other agencies are audited. For instance, we passed the law of 2008 of the Audit Act that where the public funds, where the government has an interest, it must be audited. So when you pass such a law not consistent with the other, it becomes very contradictory. I would think that it's very necessary within this law that also the Attorney General, that the powers which Auditor General has to audit all manners for the purpose of transparency and accountability, I think the Administrator General should not be exempted. I beg to submit.
Okay. Honorable Organ.
Madam Speaker, this particular law is for the majority and not the minority. Because we are dealing with the smaller states. And it's a law that needs very serious attention of this House. The rich people in Uganda are very few. But those whom we are talking about, the ones who are concerned with the small estates, actually constitute the majority in the country. Right, Honorable Speaker, I want to appreciate the fact that we are aligning these laws to the demands and commands of the Constitution and Article 32, which deals with the marginalized groups, and then the rights of women under Article 33. Continuing to act without this alignment would be so invalid. So I want to appreciate, first of all, the committee for its observations and recommendations. But, Madam Speaker, I want to comment on the issue of attaching accounts of Administrator General. Just like you asked, where does the Administrator General get the income from? Is this personal money? If we say that we want to attach, is it the money of Administrator General or it is the money of the poor people? So I think that is a question that is for everybody to answer. If it's for the people, why do you want them to attach it? It is for the deceased, yes, but that money, somebody is queuing up for it. At the end, it will end up in somebody's hands. Number two, Madam Speaker, this law should be looking at, as much as possible, reducing the level of bureaucracy so that somebody can be able to attain letters of administration without all the cumbersome processes. How I wish it were possible that we even bring some of these jurisdictions to the LOC 1. Maybe our legal brains will support and think about that. Is it possible? Because we have given everything to courts of law, we are giving everything to Administrator General. These are people who are seated mostly in Kampala. When you talk of High Court, in my district, there is no High Court. My people have to travel to Kampala. How much money do you have to pay under COVID? 40,000 times 2, 80. You come once, twice, 3 times, you have not yet got what you want. Madam Chair, I beg that you give me, Madam Speaker, some more time. So I want to agree also with the Honorable Namgansa. Madam Speaker, when we leave too much powers with the Administrator General, they decide on the fate of the people. And this can be a problem. And the people we are talking about are the majority. These are not a few people. They are the majority. They're very poor, the poor of the poorest across the country. How I wish we agree and we trim the powers of the Administrator General and make this work as simple as possible through this law. Madam Speaker, I want to say intermeddling is something which is like beyond witchcraft now in this country. And there must be more strict penalties. But as we are prescribing these penalties, I would not be happy to get only one side of the penalties, like now you say in prison 1 year. Let us also provide for monetary penalties. And then also allow and say, oh, both. So that the presiding officer has the jurisdiction, he has the discretion actually to decide whether to prescribe this or that or both. Madam Speaker, if we did that, then things will be okay. This law is so urgent. It is a matter of urgent public concern, Madam Speaker. And therefore, we should not delay it, but we need to handle it with utmost care because it handles the majority, not the minority. I beg to submit.
Now, Norin.
Thank you, Madam Speaker, for the opportunity. I want to thank the committee for processing these very important bills. Thank you for the good work done. Madam Speaker, I want to seek clarification about the Office of the Administrator General. Madam Speaker, I'm wondering, is it not possible that this office can be decentralized so that the people with these small estates, who are the majority, like my brother Honorable Cyrus has said, are able to easily access this office? Because when they have to handle the surviving spouses, when they need to fight for the estate of the deceased before they can access the letters of administration. Now my question is it not possible that there can be decentralization for easy accessibility of such services? I thank you, Madam Speaker.
Members, just for the record, the issue of decentralizing this office, it is one of the things I spoke about when I first came to Parliament in 1989, that we needed to decentralize these offices. Any more comments? Yes, Honorable Kaiser.
Thank you, Right Honourable Speaker. I thank the committee for the proposal to amend the Administrator General's Act. Madam Speaker, this law is a 1993 law. That means these are 88 years down the road. And like the chairperson of the committee said, this is too much, this is too long a time. A lot has changed in terms of the economy. A lot has changed even in terms of the properties, the laws pertaining to properties and acquisition. So because of the time lag, it's indeed the right time for us to amend this and cater for the changing economic times. I agree with the committee recommendation that the penalties be strengthened. 3 months of imprisonment or payment of 200,000 shillings is not deterrent enough. Madam Speaker, we should adopt the currency points, because the currency points are not affected by inflation. Because if you are to maintain the shillings, penalties in shillings, that means maybe time with time we need to revise. And from the laws, the amendment of the laws, current points are more trendy, and it's the global dynamic that we should follow. So those will be more deterrent, and we should not have to revisit them time over time. And then we also need to harmonize with other laws. We talked about the Succession Act, for instance, where properties like the matrimonial home is protected. This is in line even with Article 33, where women and also the vulnerable groups are protected. Such people are like the orphans, of course, who are left behind, or the children who are left with one parent. Those are the categories of persons we want to protect by amending the law or harmonizing it with other laws like the Succession Act. Madam Speaker, finally, the cost of administration also. Like the chairperson said, they gave an example where someone had 200,000 on the account, and then the cost of administration is 200,000 or even more. That means the vulnerable people who are supposed to benefit from that estate cannot benefit because of such costs. So I also agree that the costs for the small done away with, so that the vulnerable people who are our target can benefit without inconveniences. Thank you, Right Honourable Speaker.
Honourable members, I think there are no contributions. Honourable Attorney General, please, I really want to understand which account of the Administrator General is subject to attachment. Because I don't want to be told that, you know, the money in your estate is less because there was a garnishee order.
Madam Speaker, you made an earlier observation, and it was spot on. The accounts of the Administrator General are the accounts on which they hold proceeds of the beneficiaries. Proceeds of estates which they are administering. Now, if you attach them by court order, then the beneficiaries will not have access to those accounts, will not receive proceeds as required. The Administrator General, we are not talking of any separate administrative account. No, we are talking of accounts to benefit a particular beneficiary.
Notification number 11 of 2017, it was administrator and another, and that case cannot be asked since the funds. That's the legal provision. So, and for the question that this be the Administrator General's amendment will be read. I have it.
The Administrator General's Amendment Bill 2019, Bills Committee stage. Clause 1.
Madam Speaker, Clause 1 is on the short title and commencement. We want to delete Clause 1, and our justification is that Clause 1 is redundant in light of Sections 14 and 15 of the Acts of Parliament Act, Cap 2.
Members, the question is that Clause 1 be deleted. Those in favor say aye, the contrary no. Okay, I have it.
Clause 2.
Clause 2 is on the amendment of Section 1 of the Administrator General's Act. In Clause 2, in the proposed amendment to Section 1 of the Principal Act, we want to insert the following new paragraph immediately after paragraph A and renumber the clause accordingly. B, inserting the following definition after paragraph C as follows. Child means a person below the age of 18 years, including an adopted child. And our justification is to define a child.
Members, put the question.
Madam Speaker.
Yes.
Madam Speaker, we had time to harmonize with our colleague members of the committee, and our harmonized proposal is we reject the proposal of the committee to insert a new definition on a child since it is redundant and not used in the Principal Act. Our original position before harmonization was still a rejection of the proposed amendment. We are saying there is no need to define the term child under the Administrator General's Act because it is not used under the Administrator General's Act. In matters of succession, the term child is applied in respect of all children of a deceased person, regardless of whether the child is a minor or a major. If the definition is carried, there will be a confusion in the usage of this term. I beg to submit.
Do we have the Principal Act here?
Madam Speaker, would like to concede on that one, on Clause 2.
But there's no definition of child here. There is none?
No, there's no definition of child.
Okay. Yes, Honorable Silas?
Madam Chair, I don't know whether we are allowed to make any other definition of a child beyond that defined in the Constitution. So to me, even if we had no definition, I think under the Constitution, it is clearly stipulated. I don't know whether it's necessary to have that definition here. Among the most common definitions, I think the one of the child is so common.
Since the mover has withdrawn the proposal, I put the question that clause 2 do stand part of the bill. Those in favor say aye, the contrary no.
Clause 3.
Clause 3, Honorable Chair.
Clause 3 is an amendment of Section 2 of the Principal Act. In Clause 3, substitute for the proposed amendment to Section 2.5 with the following. Section 2.5 of the Principal Act is amended by substituting for the words which does not appear to exceed 2,000 shillings in gross value, the words where the property is in the form of cash, cash in the bank, death gratuity, household assets, vehicles or any other movable property and does not exceed 2,500 currency points. Justification is to cap the jurisdiction of the agents of the Administrator General to estates over which such agents can exercise summary powers of the Administrator General without express authorization of the Administrator General or court to only small estates of a total value of 50 million Uganda shillings, being the maximum value of a small estate as prescribed the Administration of Estates, Small Estates Special Provisions Amendment Bill, to clearly state the jurisdiction of the agent to an aggregate property value rather than the proposal in the bill which had no such limit and be open to a currency points in order to shield the provision from inflation. Agents appointed by the Minister or the Administrator General jurisdiction over small estates will bring services closer to the people, reduce the cost of obtaining letters or probate in estates whose values fall within their jurisdiction, ensure that the beneficiaries draw as much value from the estate and allow for the just and effective administration of estates of deceased persons irrespective of their value without eroding the beneficial interest of the estate.
Members, you have heard the proposal.
Madam
I put
Speaker.
the question.
Madam Speaker.
Yes, Attorney General.
Madam Speaker, our harmonized response to Clause 3. In Clause 3, it says substitute the proposed amendment to Section 2, subsection 5 with the following. Section 2, subsection 5 of the Principal Act is amended by substituting for the following words, which does not appear to exceed 2,000 shillings in gross value. The words where the property in the form of cash in the bank, death gratuity, household assets, vehicles, or any other movable property does not exceed 750 currency points. That appears to be our harmonized position. However, I don't know if the chair is departing from it.
What would be the equivalent of 2,500 currency points in shillings?
Madam Speaker, 2,500 would be 50 million. 50 million Uganda shillings. Oh, 2,000. 2,500 is 50 million. Yes, it is. So, Madam Speaker, I do concede on the harmonized position.
For 700?
For 750 currency points.
That would be how much money? 15 million?
15 million.
Okay. Okay. Then that means we go back to, okay, instead of 15 million, we say 750 currency points.
Yes, we say 750 currency points.
Okay.
After that, Madam Chair, I would love to get support from the committee and the minister. If we are going to give out work to agents of the Administrator General, are we prescribing any penalties against misbehavior? Where we give somebody work and then they go on.
I think let's first deal with the amendment, because so we take the Attorney General's amendment. Okay, Honourable members.
Yes, Madam Chair.
I put the question that clause 3 be amended as proposed by the Attorney General. Those in favour say aye, the contrary no. Ayes have it.
Clause 3 as amended.
Question is that clause 3 as amended do stand part of the bill. Those in favour say aye, the contrary no.
Aye.
Ayes have it.
Clause 4.
Honourable Chair, you have
Clause 4, amendment of Section 4 of the Principal Act. In Clause 4, substitute for the proposed amendment to Section 45B the following. Substitute it with the following. Section 45B of the Principal Act is amended by substituting for the words does not exceed 20,000 shillings the words where the property is in form of cash in bank, death gratuity, household assets, vehicles, or any other movable property, and does not exceed 2,500 currency points. Justification to curb the jurisdiction of Administrator General to estates over which the Administrator General can administer without letters of administration or other formal proceedings or notice, take possession and administer to the largest of the small estate, which is of a total aggregate value of 50 million Uganda shillings as prescribed in the Administration of Estates, Small Estates Special Provisions Act, clearly states that jurisdiction of the Administrator General limited to a defined aggregate property value rather than the proposal in the bill, since the failure to expressly state the total value of the estates over which Administrator General may have jurisdiction over may lead to abuse of such powers. To express the value of the estate in currency points in order to shield the provision from inflation, granting the Administrator General jurisdiction over small estates, which will bring services closer to the people, reduce the cost of obtaining letters or probate in estates whose values fall within their jurisdiction, ensure that the beneficiaries draw as much value from the estate and allow for just and effective administration of estates of deceased persons, irrespective of their value, without eroding the beneficial interest of the estates. Consequential amendment arising from the amendment of Clause 3 of the bill.
Madam Speaker, our harmonized position to that, in Clause 4, substitute for the proposed amendment to Section 4, subsection 5, Clause B, with the following. Section 4, subsection 5B is amended by substituting for the words does not exceed 20,000 shillings the words where the property is in the form of cash in the bank, death gratuity, household assets, vehicles, or any other movable property does not exceed 750 currency points.
But you know, you are interested when you say harmonized. You have got different things. The chairs got different things. I don't know what you harmonize.
Madam Chair, I concede on the 750 currency points, bringing it really to an equivalent of 15 million Uganda shillings.
Honourable members, the question is that clause 4 be amended as proposed by the Attorney General. Those in favour say aye, the contrary no. Ayes have it.
Clause 4 as amended.
Questions is that clause 4 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 5.
Clause 5, Honourable Chair.
Clause 5, amendment of clause 5 of the Principal Act.
Delete.
We propose to delete clause 5. The justification is that the proposal will impose an unreasonable requirement on the widow or widower to obtain a letter of no objection from the Administrator General in total disregard of the fact that a widow or widower obtains during the subsistence of a marriage interest in the property that constitutes matrimonial property and therefore cannot be regarded as any other person. The provision will subject the widow or widower's proprietary rights to the desires and whims of the Administrator General, a matter that's contrary to the proprietary rights of such a person as guaranteed in the Constitution. The provision will also have the effect of curtailing the enjoyment and exercise of property belonging to the widow or widower, since he or she will lose the right to administer his or her property and bestows the same to the administrator. And lastly, the proposal is contrary to the amendment proposed in the Succession Amendment Bill 218, where the committee recommended the adoption of a proposal to grant unfettered right to the surviving spouse to apply for and be granted letters of administration over any person, including the Administrator General.
Madam Chair. Our harmonized position, Section 5 of the Principal Act is amended by A, repealing the words or widower or widow of the deceased, his or her attorney duly authorized in writing, authorizing that person to administer the estate of the deceased. B, by inserting immediately subsection 3 the following: the surviving spouse shall have preference over any other person in the administration of the estate of the deceased spouse. Delete spouse and replace with intestate, because a surviving spouse cannot have preference over an executor. This would clarify the position of the law. Furthermore, the reference to the surviving spouse under subsection 4 may be disregarded by the Administrator General where a surviving spouse is not a fit and proper person to administer the estate of the deceased spouse, or B, the Administrator General finds necessary in the circumstances of the estate to grant the administration of the estate to another person. I beg to submit.
Babadiri? Then Honorable Nordin, can someone assist at the podium? For the chair of the committee,
yeah, yes.
deleting that clause would mean retaining the original text in the law.
It's not there.
Honorable, Honorable
Chairperson, thank you very much for giving me the time. Madam Speaker, I thought these people agreed and they harmonized the positions. But now the committee is bringing a different report. The Attorney General is bringing another harmonized position. May I know with whom the Attorney General harmonized this position? Because the report we are getting is different from what he's telling me. And my feeling is that maybe the Attorney General is just sneaking things which they never discuss with the committee. Because the report is different from what he is reading to us. Can you clarify, or is it procedure right for the Attorney General to come around with the harmonized position? I don't know with whom he harmonized his positions. Thank you. Because it's continuing. Thank you.
Okay, Honourable Member, it seems the Attorney General is smuggling amendments. Because the committee continues to bring a different position. What did you harmonize that with who?
Thank you, Madam Speaker. I want to appreciate the position of the committee on this provision. The committee is making effort to cater for the rights of the surviving spouse. Now, when the Honourable Minister says circumstances where the surviving spouse may be unfit to administer, what are such circumstances? If the spouse is surviving, that alone is enough to enable the spouse take over the estates of the deceased spouse. So I want to reject the proposal from the Honourable Minister.
Yes, Honourable Ramazan.
Madam Chair, to add on what the Honourable colleague has just mentioned, from my colleague, the Attorney General, is saying where the Administrator General finds the spouse unfit, and I had talked about the same, that in the eyes of the Administrator General, you go there, what makes him or her think that you are unfit to inherit? Right now, Madam Chair, even where you find that the spouse, the surviving spouse, sometimes they don't know how to read or don't know what to write, still they have the right to give responsibility either to a child or another person they feel, as long as it's in the lineage, within their powers. But what he's suggesting, it deprives the surviving spouse of such powers, and they remain there on the mercy of the so-called administrator to decide whether you are fit or unfit. What do you mean? When I got married to this lady, why was I not unfit? The one who appreciated me has gone, and you leave me at the mercy of the so-called Administrator General to find me unfit or fit. No, we reject that, Madam Chair.
Yes. Honourable Sosi and then Honourable Augon.
Thank you, Madam Chair. The justification is maybe what Attorney General missed to read. Let me read it verbatim for the House to decide. The reason was to codify a practice developed by courts to wherein widows and widowers are no longer given priority over the administration of estates of the deceased partners due to the reality of families. Judges where a deceased person is surviving from different women or in polygamous families, since court is not sure of the number of partners or children the deceased had at the time of death. In order to protect the interests of all the beneficiaries of such estates, there are instances where it may be preferred that the administration is granted not to the surviving spouse alone, but to any other person or a group of people with or without the surviving spouse. That was the justification, Madam Speaker. With the nature of our families today, if you settle the surviving spouse alone, it is not that the surviving spouse is unfit, but to create room to cater for all the other beneficiaries who may be neglected by the surviving spouse. I beg to submit.
Madam Chair, we are already attempting to amend the Succession Act before it's time. That's where the challenge is. We should have actually started with the other bill before this one. We are trying to take time on it, but we must really work on that bill. One, if we are talking about preference, and we are giving preference to the will, and you ignore a surviving spouse, we must be able to go back to the Constitution and remember that our Constitution speaks to rights that people have. Are you going to deny them the rights? So this clause, I don't know, we might take one full year to agree because there's already a problem. I know for sure, Madam Speaker, Madam Chair, if you allow on the other side spouses all the powers to inherit, a man, so that I'm just giving you to speak, rise up and kill a man because she knows tomorrow the law is protecting her and she can be able to take over property in full swing because they are saying surviving spouse. But on the other side, a man can also do the same. But for now, this is what I was trying to suggest, Madam Speaker. We provide for an exception.
Now, honour members, this bill belongs to the Attorney General, but the Attorney General is now bringing other amendments to this bill here on the floor. You are smuggling. And I don't understand what you harmonized. I don't see any harmony. I don't see any harmony in this room.
Madam Speaker, what the Attorney General is referring to as harmonized are his proposals to which I accepted, but
which you accepted.
We continue with our position, but I'm reading the committee position because that is what we have here.
But Honorable Chair, you cannot say that there are those he made which make sense, others don't. You have said, let us delete clause 5. Now for him is amending even his clause 5.
Our position, Madam Chair, is the deletion of clause 5.
Yes, Attorney General, you cannot smuggle amendments here. And this is your own bill.
Madam Speaker, there was an attempt by our drafts team to have a discussion with the chair. Certain positions were arrived upon. Be that as it may, as a ministry, we have our own responses, which I had omitted to put on record in favor of those that I believed had been agreed upon. In the event that you find it unpalatable to carry what I considered harmonized, I want you to allow me put on record our responses as a ministry.
This is your bill. Any proposals for amendments should have gone to the committee and they appear in the report. But now we have the committee amendments, we have yours, we have the text of the bill. You're not being fair to us. You cannot amend on the floor of this house. Did you actually hold a meeting to harmonize this thing? Did you actually hold a meeting with the committee?
The chair attended the harmonization. Did you?
No, Minister, the harmonization, the bill is a bill in the House. Harmonization must take place in Parliament. It must take place before the committee, not with one member of the committee. Vero.
Madam Speaker, we have a committee position which was brought to this House, and it is what we are processing. There has been no harmonization that the committee knows. We sat yesterday, Madam Speaker, we sat today, and nothing was ever brought before the committee. We cannot now have positions or new things while on the floor, Madam Speaker. We stick to our position.
Madam Chair, this is not the first time that the learned Attorney General is smuggling their views.
Madam Speaker, I do not, with me I have, and I know of a meeting that the Speaker asked should take place for us to harmonize on the succession amendment bill. It is during that same meeting that we decided to discuss the Administrator General's bill. What is being presented here is not a smuggled position. It may not have been presented to the members of the committee. And like the Speaker said, it should have gone back to the committee. And because of the Speaker's observation, I concede, but it is not a smuggled position.
Now, so, honourable members, I think let us be clear. We cannot have amendments made on the floor of this House which have not been considered by the committee. If you went beyond succession and moved to another bill, which we had not instructed you, you are going beyond our instructions. And the succession vote is not yet here.
Madam Chair, let me complete what I had started, because I even did not see the point of order that he gave me. One, I saw in the report where Attorney General, mover of the bill, interface with the committee. If you could not finish at that time, at the tail end you should have harmonized this, and you keep on saying harmonized position. Harmonization with who? You're supposed to have this harmonized position in the committee. And now I even want to propose. I want to propose a motion that that we stand over everything. These people go and harmonize their what? Their clauses.
But it seems they did not share.
Before.
Yes. But now we can.
That harmonization supposed to be done out of this House. Madam Chair, I said I want to propose that the
Yes, Honorable Saliro, and then Honorable Kakunda.
Thank you very much. Chair, I think as a committee, our views are on the report. If the learned Attorney General and my classmate Jackson wanted to have these matters harmonized, he should have come back in the committee. Chair, I propose the report is here and the views are, and that report is already a property of this House. We proceed to consider what is on the floor of the House to save time. I beg to submit, Chair.
Okay. Yes, Honorable Kakunda.
Madam Chair, for me, my point was we had already ruled that really, once a committee report is the property of the House, the minister is called in the meetings, he attends to give his position. There is a bill of government, which is of Attorney General, so we are discussing a report. If any, apart from that, I don't think that it can be entertained. So the way forward is we deal with the report and what is in the bill. If it's not accepted, then we amend it at the whole House, but not any other amendment apart from the bill given to the committee and the report read by the committee.
Members, I put the question that clause 5 be amended as proposed. That is by deletion. Those in favor say aye. The contrary, no. Ayes have it. Clause 6.
Clause 7. Clause 6.
Clause 6. I put the question that clause 6 do stand part of the bill. Those in favor say aye. The contrary, no. Ayes have it.
Clause 7. Clause 7, amendment of section 11 of the Principal Act. For clause 7, they substituted the following. Replacement of section 11 of the Principal Act. For section 11, they substituted the following. When a person dies, whether within or without Uganda, leaving no property within Uganda, a person who, without being duly authorized by law or with the authority of the Administrator General and agent, takes possession or causes to be moved any property of a deceased person, unlawfully refuses or neglects to deliver any such property to the Administrator General or his or her agent or any other person when called upon to do so, or intermeddles with the estate of a deceased person, commits an offense and is liable on conviction to a fine not exceeding 1,000 currency points or imprisonment not exceeding 10 years or both. 2. A person is taken to intermeddle in the estate of the Administrator General, an agent general, or a person to whom probate or letters of administration have been granted by court, takes possession or disposes of a deceased person's property, or B, does any other act which belongs to the office of executor or administrator. 3. Subject to section 268 of the Succession Act, the Administrator General may intermeddle in the estate of a deceased person where it is urgently necessary for the purposes of A, preserving the estate from abuse, B, providing for the deceased's funeral, C, providing immediate necessities of the deceased family, D, preserving and prudent management of the deceased person's business, including preserving the deceased person's goods of trade, or E, receiving money or other funds belonging to the deceased person. 4. The duration for which the Administrator General may intermeddle in the estate of the deceased person pursuant to subsection 3 is 6 months from the date of the deceased person's death or until the grant of letters of administration or probate, whichever first occurs. 5. For purpose of this section, the Administrator General or its agent may at any time before grant of letters of administration or probate take any action that is necessary for the preservation of the estate of the deceased person. 6. A person aggrieved by the decision of the Administrator General or its agent may apply to the High Court for redress. 7. A person who A, willfully refuses or neglects to deliver any property to the Administrator General or her agent when called upon to do so, called upon so to do, B, lawfully intermeddles in the estate of the deceased person and fails or neglects to report to the Administrator General or its agents the particulars of the property and of the steps taken to preserve such property, commits an offense and is liable on conviction to imprisonment for 3 years or to a fine not exceeding 72 currency points or to both fine and imprisonment. The justification is to align the provision with section 268 of the Succession Act to cap the duration of the Administrator General the Administrator General may intermeddle in the estate of a deceased person to 6 months or upon grant of letters or probate, whichever first occurs, to ensure compliance by creating offences against persons who neglect orders from the Administrator General, to limit the powers that can be exercised by the Administrator General to only preserving the estate rather than administering the estate of the deceased without lawful authority.
Madam Chair, I would like to seek clarification and probably guidance from you, Madam Chair. Honorable Silas talked about it. Who is defined as the agent of the Administrator General? Because as we talk now, Madam Chair, every person who works in the Administrator General's office, they have become agents. They do the same work. You find them doing the same work like the one the Administrator General would do. If we leave the word agent like that, we continue to get more confusions of those. All the personnel now, they think they have the same powers. So, should we say the agent would be someone who has been assigned in writing, or would be like how? Because the way we leave it like that, who is the agent? Honorable Silas talked about it. I seek your guidance, Madam Chair.
Honourable members, under the Interpretation Act, interpretation section of this law, it is stated as was an agent, means an agent of the Administrator General duly appointed under Section 2 subsection 4. And Section 2 says, the Minister may appoint any person in the public service or any chief of the rank of Gomborda chief or of an equivalent or higher rank to be the agent of the Administrator General in any area of Uganda. But the Administrator General may appoint any person, whether eligible to be appointed by the Minister under this subsection or not, as the Administrator General shall think fit to be his or her agent in respect of any particular estate, in respect of any matter arising out of any particular estate. So you have to be appointed formally by the Administrator General.
Right, Honourable Speaker, for purposes of clarity, it is the town clerk, the sub-county chief, the chief administrative officers. Those are the ones we use as agents of the Administrator General.
Madam Chair, if the definition is there already, that's okay. But my issue also, in addition to the concern from the Minister, is that, you know, as Uganda now, in nearly every business that we conduct, there are brokers. There are brokers who purport to be agents, who purport to be the Administrator General himself. Are there any penalties prescribed under this bill to deter such people from acting the way they act? Because I believe they are the ones who are surrounding you, around the ministry, purporting to be from the Administrator General, and they dress very smartly.
Can you respond to that? What are the sanctions? What are the sanctions to imposters? Those who don't have that Administrator General's official authority.
Those are impersonators. They can be charged for impersonation or obtaining money by false pretenses because they are not legal employees of the Administrator General.
Okay. Okay. So we had received the proposal under clause 7. On our members, I put the question. Clause 7 be amended as proposed. Those in favor say aye. The contrary, no. I have it.
Clause 7 as amended.
Which that clause 7 as amended do stand part of the bill. Those in favor say aye. The contrary, no. I have it. Now, Chair, I think you have a new clause.
Insertion of a new clause in the bill. The bill is amended by inserting the following new clause immediately after clause 9 as follows. Insertion of section 9A in the Principal Act. The Principal Act is amended by inserting immediately after section 9 the following. 9A. Duration of administration or execution. 1. Where the Administrator General or an agent of the Administrator General takes over and administers an estate with or without an order of court under this Act, the Administrator General or an agent of the Administrator General shall carry out the duties and functions authorized by this Act or by the grant of probate or letters of administration for a period not exceeding 3 years. 2. Notwithstanding subsection 2, court may on application extend the duration prescribed in subsection 1 for a further period of 3 years if it is satisfied that A, it is in the best interest of the beneficiaries to extend the period, and B, the Administrator General or the agent of the Administrator General has 1. Complied with the provisions of this Act or any condition of grant or probate or letters of administration, and 2. Obtained the consent of all the beneficiaries in the estate for which the grant was made. The justification is that the imposition of a duration for administering an estate by the agent or Administrator General is to ensure that the Administrator General or an agent of the Administrator does carry out the functions of the office within the shortest time possible. In this case, 3 years, and to ensure that the Administrator General does not unreasonably hold on to this estate indefinitely. To harmonize the Administrator General's Act with the amendments made to the Succession Act.
Now, members, you've heard the proposal for a new section. I put the question that new section be. Yes, Honorable Ogon.
I would love to obtain clarity from the chair as to which Succession Act she's referring to. Is it the one in force or the one we are trying to amend and is not yet here?
Madam Speaker, our proposal is that instead of 3 years, we talk of 2 years. Shall carry out duties and functions authorized by the Act or by the grant of probate or letters of administration for a period not exceeding 2 years instead of 3 years.
Honorable Robina, what do you say about that?
Madam Chair, I don't have a problem with it because they are reducing the duration of time during which they shall administer the estate of a deceased person. They are not holding on to the administration of the estate. I think it's beneficial to the
estate.
To the estate.
Okay, members, I put the question that the proposal be further amended by substituting 2 years for the 3 years. So I now put the question that a new clause be introduced as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 8.
Put the question that clause 8 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 9.
Put the question that clause 9 do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 10.
Clause 10, Honorable Chair.
Clause 10, amendment of section 16 of the Principal Act. For clause 10, they substituted the following. Replacement of section 16 of the Principal Act. For section 16 of the Principal Act, they substituted the following. 16, powers to dispose of property. 1. Subject to sections 27 and 36 of the Succession Act, the Administrator General may, with the written consent of the surviving spouse, lineal descendants and dependent relatives, dispose of the property of his or her administration either wholly or in part, and either by public auction or private treaty, as he or she in his or her discretion may deem to be in the best interests of the estate. 2. Where a beneficiary of the estate is a minor, the consent required in subsection 1 shall be given by the guardian of the minor, and where the guardian of the minor is the executor or administrator, the consent shall be granted by court. 3. Notwithstanding subsection 1, the Administrator General shall dispose of the property of an estate under his or her administration only where A, the disposal is beneficial to the estate. B, the disposal is beneficial to the beneficiaries in the estate. C, the sale is necessary to cater for the basic needs of the surviving spouse and lineal descendants or any other person entitled to benefit under the estate. Or D, the disposal is necessary for settlement of the deceased person's debts, including settlement of the deceased person's tax obligations. 4, the Administrator General shall account to the estate the proceeds arising from the sale or disposal of any property belonging to the estate. 5, in disposing of property under this section, the Administrator General shall give first option to a beneficiary of the estate to purchase the property. 6, the Administrator General, the agent of the Administrator General, or any other officer of the Administrator General or Administrator General's office shall not be eligible to purchase property of the estate. 7, any disposal of the property belonging to the estate of a deceased person in contravention of this section shall be void. The justification: to exempt the disposal of matrimonial property and other property as prescribed in sections 27 and 30 of the Succession Act, to impose restrictions on the sale of property of the deceased person, for transparency and in order to obtain value for money, to bar the Administrator General, the Administrator General's agent, or any other officer of the Administrator General from purchasing the property belonging to the estate under his or her management, to enhance accountability by imposing an obligation on the Administrator General to account to the estate for the proceeds arising from the sale of property, and lastly, to grant a preemption rights to a beneficiary of the estate to purchase the property before it is offered to a third party.
Now, members, you have the proposal for amendment of clause 10. I now put the question that clause 10 be amended as proposed. Yes, Honorable Atat.
Chair, I'm interested to know whether there is any penalty, because the proposal given here by the committee is quite good, that the Attorney General, his agents, or any other person associated with that office should purchase the property. But you know the way Ugandans do things. The property could be purchased in the name of a niece or a nephew or something like that. Now, could they attach to this? Should it be discovered later that actually the administrator or his agent purchased the property? That number spear.
Honorable Chair, can you respond to that?
Madam Chair, number 7 clearly says that any disposal of the property belonging to the estate of a deceased person in contravention of this section shall be void. So it will be an empty transfer. Yeah, it doesn't hold.
Okay, Honourable members, I put the question that clause 10 be amended as proposed. Those in favour say aye, the contrary no.
Clause 10 as amended.
Question that clause 10 as amended do stand part of the bill. Those in favour say aye, the contrary no.
Clause 11.
No, there's a new...
Insertion of new clause immediately after clause 10. The bill is amended by inserting immediately after clause 10 the following. Insertion of section 16A in the Principal Act. The Principal Act is amended inserting immediately after section 16 the following. 16A, power to open and operate bank accounts. 1. The Administrator General shall, with the authority of the Accountant General, open and maintain such accounts as are necessary for the performance of the functions of the Administrator General or an agent of the Administrator General. 2. The Administrator General or an agent of the Administrator General shall deposit all funds received on behalf of an estate of the Administrator General or an agent of the Administrator General in administering under this Act. Under this Act onto which agent of the Administrator General is administering under this Act. Excuse me a bit. The second 16A2 should read: the Administrator General and agent of the Administrator General shall deposit all funds received on behalf of an estate the Administrator General or an agent of the Administrator General is administering under this Act onto the account. The justification is the power to open bank accounts will enhance transparency and accountability by ensuring that each estate has an account opened for it by the Administrator General or his or her agent onto which funds received for the estate are deposited thereon. The provision will ensure that funds for individual estates are not deposited onto the consolidated fund, considering that these funds do not belong to government, and also to ease access to such funds by the beneficiary.
First, you had the proposal for new clause. I put the question that a new clause be started as proposed. Yes, Honorable Silas.
I do not know whether it's not necessary for these accounts to be published so that the concerned people have information, so that the transparency is actually transparent. So if there's any provision, I don't know whether it's necessary that we provide that after opening these accounts, they should be published immediately. I don't know whether it's necessary.
But is that a breach of privacy by the banks?
Because, Madam Chair, I would think that we are not mentioning the amounts in the account, but just to publish and say this account has been opened for this estate. I don't know whether it's necessary.
No, they don't open accounts for each estate. There is a account where they put all the money, the estates of Guru, the estates of Kitgum, and so on. So it's not for every estate.
I concede.
Okay. Members, I put the question that a new clause be introduced as proposed. Those in favor say aye, the contrary no. Let's have it.
Clause 11.
Put the question that clause 11 do stand part of the bill. Those in favor say aye, the contrary no. Let's have it.
Clause 12.
Honorable Chair, you have an amendment.
Clause 12, amendment of Section 18 of the Principal Act. In Clause 12, in the proposed amendment, Section 18(1), substitute for the words "the Gazette" and also in one or more local newspapers appearing in subsection 1, the words "in at least one newspaper of wide national circulation and using any other means of communication as may be appropriate for the particular estate." The justification is to make the notification to be made in a newspaper of wide national circulation to notification is received in areas beyond where the estate is situated.
Members, the question is that clause 12 be amended as proposed. Those in favor say aye, the contrary no.
Clause 12 as amended.
Question that clause 12 as amended do stand part of the bill. Those in favor say aye, the contrary no.
Clause 13.
Honorable Chair, you have a
Clause 13, amendment of Section 19 of Principal Act. In Clause 13, in the proposed amendment, Section 19(1), substitute for all the words appearing after the words "the Gazette" appearing in subsection 1 with the words "at least one newspaper of wide national circulation and using any other means of communication as may be appropriate for the particular estate." Justification: to make the notification to be made in a newspaper of wide national circulation, to that the notice is received in areas where estate is situated.
Put the question that clause 13 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 13 as amended.
Put the question that clause 13 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it. Of a new clause, Honorable Chair.
Insertion of new clause. The bill is amended by inserting immediately after clause 13 the following: amendment of Section 20 of Principal Act. Section 20 of the Principal Act is amended: A, by substituting for subsection 4 the following: the fees, charges and reimbursements authorized by this Act shall be charged on the estate and paid after payment of funeral expenses and wages due for services rendered to the deceased within 3 months preceding his or her death by any laborer, artisan, or domestic servant. B, by inserting immediately after subsection 4 the following. 4A, the fees, charges, and reimbursements referred to in subsection 4 shall be deducted from any monies received by the Administrator General in the course of the administration. The justification is to align the Administrator General's Act with the provisions of the Succession Act, especially sections 280, 281, 282, and 283, which set out the priority for payment of fees, charges, and disbursements out of the estate.
Now, members, you've heard the proposal for a new clause. I put the question that a new clause be introduced as proposed. Those in favor say aye, the contrary no. Clarification? No, Lynn?
Thank you, Honorable Chair. The clarification I'm seeking, who controls the powers of, how do we control the powers of the Administrator General? In this case, what if what if the costs are, how do we control this? Because it's like we are putting so much power here, and I'm afraid it can be abused.
Madam Chair, if a beneficiary to an estate is not satisfied with the handling of that estate by the Administrator General, he can cause an inquiry. He can even sue the Administrator General. The Administrator General can be called to account. That way, you are able to ascertain.
In addition, the official charges, I think, are issued by the judiciary in an instrument, so you might have an idea about how much it costs to file, how much it costs to swear an affidavit, how much to advertise in the Uganda Gazette or the newspaper. I think the charges are fairly standard. Members, I put the question that a new bill be introduced as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 14.
I put the question, clause 14. Honorable Chair, you have an amendment.
Clause 14, amendment of section 24 of the Principal Act. In clause 14, in the proposed amendment, section 24, substitute for the words outside Uganda, the words in a country other than Uganda. Justification for consistency with the nomenclature used in such circumstances.
Members, I put the question that clause 14 be amended as proposed. Those in favor say aye, the contrary no. Ayes have it.
Clause 14 as amended.
Questions that clause 14 as amended do stand part of the bill. Those in favor say aye, the contrary no. Ayes have it.
Clause 15.
Honorable Chair, you have a proposal.
Clause 15, amendment of section 27 of the Principal Act. For clause 15, they substituted the following. Replacement of section 27 of the Principal Act. For section 27, they substituted the following. 27. Guardian to receive minor's share. 3. Where a person entitled to share under the will of a deceased person or in the distribution of an estate being administered by the Administrator General is a child, the Administrator General shall transfer and deliver the share of the child to the guardian of the child. 4. The guardian of the child shall manage the property delivered to him or her in subsection 1 in a prudent manner and shall A. Apply the property for the benefit of the child. B. Take reasonable steps to safeguard the property of the child from loss or damage. And C. Annually account in respect of the child's property to the Administrator General, the surviving parent, if any, court, or any other person as court may direct. Justification: in compliance with the Children's Act and the Succession Act, to require the share of the child is transferred to the guardian of the child.
to change the nomenclature used from minor to child, since the word child is the one that's normally used, to define the word child.
Now, honourable members, I don't know, maybe it's not important, but no, a minor is a minor. For instance, if you have a child of 3 who cannot write, sorry, the issue of the minor are children really who are really young. They are children, but they are minors. A child of 16 may write, but this minor of 4 years has no capacity to do anything. So I don't know why you want to remove the word minor, because that person is a child but has not reached the age to take action.
Madam Speaker, the reason we agreed to the word child, when making this amendment, we are also looking at the Succession Act. And as we get there, you will see we have made provision for the welfare of a child. And if we go with a strict interpretation of a child, it stops at 18. And yet we are trying to stretch the welfare to 25, considering the time our students take to go through school, up to around 25 when they finish university. So that's why we want to use the word child in a blanket sense instead of minor.
No, a minor is a minor. You know, for instance, a child of 12 cannot commit an offense in law. That one is a minor by law. So,
Madam Speaker, our understanding is that this child and minor be used or interpreted depending on the circumstances and the law. If it is in respect of the succession, where we are referring to welfare and we are saying the welfare should cater for a child, and yet we know we want to stretch it to around 25 years, would rather have that child accommodated there. But if you are talking of minor in terms of what we call dole incapax, the capacity to commit a crime, that would be in the criminal sense, that would be different.
This Administrator General, administering an estate, maybe he's dividing the estate among all the people. There's a child of 6 months, there's a child of 7 years, there's a child of 23. So the portion of this child of 3 is given to the guardian, because this person is a minor.
Madam Chair, when you actually look at the Succession Act, minor is defined as any person who has not attained the age of 21 years, and minority. So, and then children, issue, lineal descendant include legitimate, illegitimate, and adopted children. So we thought the definition of child would rather encompass all this.
Bring a law which you haven't done. It's in the future.
Clarification, Chair.
We keep cross-referring to it.
Succession Act, we haven't done it. Yes, Honorable.
Chair, what the minister said was that we are taking care of children who could have gone beyond the age of 18, but those who are still within the school age. But Chair, you are aware of a situation in the north where I remember at one time even Parliament was petitioned for assuming that children come out of university at the age of 25, when actually children of the north, because of the experience we went through, were coming out of the university at the age of 30, 34, you know. So maybe it doesn't hurt this act if we specify the age by saying this bracket, school age, you know, does it hurt?
Madam Speaker, I simply made reference to the succession bill, which we have not yet amended. I'm humbly requesting that Mama Cecilia, we discuss that when we reach that.
Now, honourable members, the Principal Act has a provision for a minor. That's what the Principal Act says. There's a reason for having provision for the minor. So you can't just wish it away. The law of this registration, someone cannot manage their own affairs. Yes, Honourable Namgaz.
Madam Chair, I wish to seek for more clarification because the Honourable Chair, she's saying that the Administrator General can transfer property to a guardian to look after this child. And in this case, I take your serious note of a minor. I have not heard the supervision role of the Administrator General after handing over this property. Because as you may be aware, honorable colleagues and Madam Chair, that so many guardians, especially on children who are still minors, or those who are not empowered enough, they even don't know where to report. These guardians can come and say, I'm going to take care of this baby, when actually they're interested in the property. Now, if the Administrator General just hands over, transfers the property to the guardian, I don't know whether his eye remains there, or now he says that everything is to be taken care of by the guardian, who may be actually a bad guardian who is coming to be near this child just because of property. So I think we need to put some strangers there, Madam Chair.
Madam Chair, we concede to your advice regarding a minor being a minor and then having the definition of a word child, but having both minor and child.
Important, because the minor is a minor, at least the child of 20 can receive on their own, but the minor one cannot. So I think we just, instead of substituting, we add this proposal. Okay, honourable members, we add a new section under section 27 as proposed by the chair. Those in favour say aye, the contrary no. Ayes have it.
Clause 15 as amended.
With the question that clause 15 as amended, do stand part of the bill. Those in favour say aye, the contrary no. Ayes have
Clause
it.
18.
Sorry,
Clause 16, sorry.
The clause 16, you have an amendment, Honourable Chair.
Clause 16, amendment of section 30 of the Principal Act. In clause 16, in the proposed amendment, section 30 of the Principal Act, substitute for the word 15 million shillings, the words 2,500 currency points. Justification to harmonize the provisions with section 25 and 45 of the Administrator General's Act, which expanded the value to 2,500 currency points, to express the currency points for consistency and to shield it from being eroded by inflation.
The members put the question that clause 6. Yes. Honourable, we're going to have a problem with the currency points.
Yes.
I was just trying to find out whether the minister, I mean the chair, intended to get the value that is equivalent to 15 million. Because if you are talking 500 currency, that's a 50 million. Yeah. Just for purposes of being certain. Did you mean to attain that value of 15 million as currency points or 50 million? Thank you.
Yes, we had agreed, I think, to do 750. 750 is what would come to 15 million. 2,500 would become 50, so it's 750 currency points.
Okay, honourable members, put the question that the currency points be adjusted as proposed. Those in favour say aye, the contrary no. Ayes have it.
Clause 16 as amended.
Put the question that clause 16 as amended do stand part of the bill. Those in favour say aye, the contrary no. Ayes have it.
Clause 17.
Clause 17, Honourable Chair, you have an
amendment. Clause 17, amendment of section 35 of the Principal Act. In clause 17, in the proposed amendment to section 35(2), delete all the words appearing after the word fund. The justification is the exemption is in conflict with section 2(2) of the Administrator General's Act as well as article 21(1) insofar as it creates a distinction between the matters that can be suffered by the Administrator General, a legal person, and any other person in Uganda whose accounts can be attached. Section 2 of the Administrator General's Act specifically grants legal personality to the Administrator General. This means the Administrator General can be sued or sue or suffer all things that a legal entity may suffer in Uganda. Government decentralized the payment of costs, damages, interest, and any related expenses of litigation in any suit against a government ministry, body, or agency. By exempting the attachment of the accounts of the Administrator General, the successful party in these suits will not be able to realize the fruits of its labor.
Madam Speaker. No, the Administrator General has no resources other than the man of the estate.
I want to re-emphasize the position. Madam Speaker, the Administrator General is not a vote. It is under the Ministry of Justice and Constitutional Affairs. The money it holds is trust money for the beneficiaries in estates being administered by the Administrator General. The section under section 35 of the Administrator General's Act, maybe I should read. The revenue of government shall be liable to make good all sums required to discharge any liability of the Administrator General if he or she were a private administrator, would be personally liable to discharge except when the liability is one which neither the Administrator General nor any of his or her agents could, by the exercise of reasonable diligence, have averted, and in either of those cases they shall not nor shall the revenues of the government be subjected to liability. Right Honourable Speaker, the Administrator General obtains money from the administration of estates for distribution to the respective beneficiaries. Attaching the Administrator General's accounts, which is not an independent vote, will starve the beneficiaries of their entitlements. I beg to submit.
Now, honourable members, I really want to appeal to you not to disturb section 35. What it is saying is that where the Administrator General has been sued, the government will meet that obligation. Because the money the Administrator General is of the estates, money coming from this bank for this family, this property for this family. So please, I think you should not tamper with section 35.
Madam Chair, I believe we have understood that because it comes out well in section 35, and we concede to that. Would be using the monies of the estates of deceased people, which would be unfair.
That clause 17 do stand part of the bill. Those in favor say aye, the contrary no.
Aye.
Ayes have it.
Clause 18.
Clause 18, Honorable Chair, do you have it?
Clause 18, repeal of Section 37 of the Principal Act. For Clause 18, they substituted the following. Replacement of Section 37 of the Principal Act. For Section 37, they substituted the following. Distribution of estate. After completion of the administration of an estate by the Administrator General or his or her agent, the Administrator General or his or her agent shall distribute the balance among such persons as appear to be entitled to it and remit the amount so due by bank transfer, bank draft, registered money order or postal order or any other method as the Administrator General or agent considers necessary. The justification is to remove the threshold and to allow transfer of such property to any person who is entitled share in the estate, to impose an obligation on the Administrator General to distribute the proceeds of the estate to the rightful beneficiaries. The proposal to delete Section 37 will create a lacuna in the law insofar as it removes the mechanism for the distribution of the beneficiaries to the beneficiaries of the estate, as well as to persons who are outside the territorial jurisdiction of Uganda. The deletion will also allow the Administrator General to retain property of the estate, thereby unjustly enriching the Administrator General to the detriment of the beneficiaries of the estate. To expand the provision to cater for the distribution of the estate by the Administrator General.
Yes, Honorable Ogun.
I would just love to earn the wisdom of the committee to find out whether there shouldn't be a formula when they are disputing this money, the balance. What formula is the Administrator General going to apply? Is he just going to divide just like based on what formula? Is it pro rata? Proportionality is going to be applied? Or he just decides that this one is bigger than the other one? Or is basing on the height? Or it is not to have a formula?
Attorney General, why are we seeking to delete this clause? Why are we repealing it and replacing with what?
I'm not sure if I've got you.
You in your proposal, you are repealing Section 37. Why and with what are you replacing it? When you repeal it?
Right Honourable Speaker, now it means I have to make a reference to the succession amendment bill once again, because that's the one we intend to use to cure the one we are deleting here. If we leave it as it is now and we pass the succession amendment bill, then we shall have to come back.
The head note says dispose of insignificant balances. That's what Section 37 deals with, insignificant balances.
Briefly, I can say, in our proposed amendment to the succession amendment bill, we are creating percentages which will cater for this. There will be no balances after that if we go with the formula as we propose.
The amendments on the succession bill are not yet on the floor. And I do not, Madam Chair, find it proper to refer to something which is yet to come. What about if they don't go through? What will happen? Anticipation is not in order because...
Attorney General, our rules preclude us from legislating in anticipation. Let us deal with this bill which is here. Forget the succession. It is not here. What's before us is this bill. So I put the question. Yes?
Chair, with respect to the administration of estate, I am privy to some best practices that actually provides for ranking when distributing the residue of the estate. where, for example, although these are mostly Western jurisdiction where spouses are given like 50%, the children, and so I think creating a schedule here where some sort of ranking analogous to what is in the succession law probably might be a way to deal with this matter. We could have a schedule particularly to deal with this, as opposed to looking at another act altogether. We could create like in the administration of estate act, generally you have schedules which ranks the distribution. And in most cases, because some of these jurisdictions are based on nuclear families, you find a spouse gets like 50%, the children maybe like 30, and then other dependents. So I think having a schedule in this case probably would be a way to cure this, as opposed to trying to deal with it through another act altogether. Thank you.
I'm sorry to dwell on this, but insignificant balance, you are looking at 2,000, 20,000, and then you're asking the Administrator General to transfer it by electronic transfer, and then it processor alone is so that's why we are proposing a deletion in the hope that we cater for this in our coming bill.
Honourable members, the 500 shillings in the law here was of 1933. So it's a lot of money. It was a lot of money. It was not 2,000. So why don't you take what the committee has proposed?
Madam Chair, I want to ask that they go by our position.
Okay. But I think the head note should not be distribution of estate, because this is the residue of the estate.
Yes, it is.
So I think you just use the old marginal note of insignificant balances, because it's a residue.
Chair, can I seek clarification? Chair, can the chair of the committee maybe clarify to us what is the specific definition of insignificance? Maybe from there we'll be able to find a way out. What is that? How much is it? How do you translate it in monetary terms? That word insignificance. Thank you.
Well, the only guidance I have is the 500 shillings that was provided for in section 37. Because section 37 reads that after completion of the administration of an estate by the Administrator General or his or her agents, if the net balance for distribution amongst heirs abroad is less than 500 shillings, the Administrator General may distribute the balance amongst such persons as appear to be entitled to it and remit the amount so due by bank draft, registered money, or postal order. I honestly cannot tell what would be insignificant.
No, but this is in the Act. This is what the present law is. I think if you change it to residue after distribution, residue after distribution.
For the
head note.
Head note.
Yes.
Yes, Madam
Because
Chair.
this is what remains after you have distributed.
Yes. That sounds better.
Let's change residue after distribution, then it's after completing etc. So on members we, yes.
The issue that was suggested by Honorable of having a shadow attached to it, because the residue might not be that residue of 1933, which is 500. It might be a significant residue, because we have not defined the word insignificant. So
we have abandoned the word insignificant and said residue after distribution.
And then we will go quiet about the amount, maybe.
Yes.
That's okay, Madam Speaker.
Okay, members, let's amend the head note to read residue after distribution of estate, and then we take the proposal by the committee. I now put the question that the section 18 be amended as proposed. Those in favor say aye, the contrary no.
Clause 18 as amended.
Put the question that clause 18 as amended to stand part of the bill. Those in favor say aye, the contrary no.
Clause 19.
Put the question that clause 19 do stand part of the bill. Those in favor say aye, the contrary no. I have it.
Clause 20.
Put the question that clause 20 do stand part of the bill. Those in favor say aye, the contrary no. I have it.
The schedule.
Put the question that the schedule do stand part of the bill. Those in favor say aye, the contrary no.
Aye.
I have it.
The title.
Put the question that the title do stand part of the bill. Those in favor say aye, the contrary no.
Aye.
I have it.
Motion for the House to resume.
Right Honourable Speaker, I move that the House do resume and the Committee of the whole House.
Questions that the House do resume and the Committee of the whole House do report thereto. Those in favor say aye, the contrary no. I have it.
Report from the Committee of the whole House.
No, Minister.
Right Honourable Speaker, I beg to report that the Committee of the whole House has considered the bill entitled the Administrator General's Amendment Bill 2019 and passed it as follows. Clause 1 deleted. Clause 2 passed with amendment, without amendment. Clause 3 amended as proposed by Attorney General. Clause 4 amended as proposed by Attorney General. Clause 5 amended as proposed by the committee. Clause 6 no amendment. Clause 7 amended by insertion of a new clause, a new section inserted. Clause 8 amended passed without amendment. Clause 9 passed without amendment. Clause 10 passed with amendment. Clause 11 insertion of a new clause after clause 10. Clause 11 passed with amendment. Clause 12 amended. Clause 13 amended. Clause 14 insertion of a new clause passed. Clause 15 amended. Clause 16 amended. Clause 17 passed without amendment. Clause 18 passed with amendment. Clause 19 passed. Clause 20 passed.
Motion for adoption.
Motion for adoption of the report from the Committee of the whole House.
I beg to move that the report of the Committee of the whole House is adopted.
Now, members, the question is that the report of the Committee of the whole House be adopted. Those in favor say aye, the contrary no. Ayes have it.
Bill third reading.
I beg to move that the bill entitled the Administrator General's Amendment Bill 2019 is read a third time and do pass.
Now, members, the question is that the Administrator General's Amendment Bill 2019 be read for the third time and do pass. Those in favor say aye, the contrary no. Ayes have it.
A bill for an act entitled the Administrator General's Amendment Act 2021.
Members, title settled and bill passes. Thank you very much.
Madam Speaker, allow me to thank you very much for steering us through the passing of the Administrator General's Amendment Bill. I would like to thank my members of the committee and to thank members of the House for your worthy contributions. This is a very old law, and it actually was dear to me because that's the first department I worked in the Ministry of Justice many years ago, and it's a very old law. Thank you so much, everybody. God bless you.
Thank you.
Oh, thank you, Attorney General. Pardon me, last but not least. Thanks, Attorney General.
Right Honourable Speaker, I wish to thank the Committee on Legal and Parliamentary Affairs, Chairperson. I wish to thank you, the Speaker, for your stewardship. Right Honourable Speaker, our earlier mix-up was because we were given leeway to harmonize, and we did have a discussion with the mover, the private member of the Succession Amendment Bill. Perhaps now you can guide us, because having harmonized with her, we are yet to forward our harmonized position to the committee. We fear to have a similar confusion that we've just gone through. We seek your guidance. Other than that, I wish to thank everybody, my senior colleagues who have participated. Thank you.
Okay. Thank you. It's still necessary to have the backing of the committee to your proposals. So you could use a few hours to do that. We shall not take it up today, to give you time to organize yourselves.
Question, Speaker. Speaker, normally when a bill is passed in this House, there are several members who persevere and they make sure that there is a lively debate before we reach a consensus, clause by clause. But it has become a practice that the chair of the committees and the minister responsible, they appreciate the speaker, they appreciate the committee, and they don't appreciate other you know, the general public like us. So, Right Honourable Speaker, I am expressing my disappointment on behalf of several of us who persevere to make sure that the baby is delivered and properly. So, Right Honourable Speaker, I would like the minister and the team to amend their ways of expressing appreciation. Thank you.
I think you are quite in order. The ordinary people are here in big numbers.
Right Honourable Speaker, to error is human. And the Mama and senior colleague and all members of Parliament who have taken part in this exercise, I wish to thank you all. The Honourable Aogon, I've heard people whispering here, they want to call him Carrier Point because he really insisted on it, demanding for clarity. It is very important. Our leader of opposition, Mama Cecilia, my colleague, the ministers, all members of Parliament, Reverend Mulindwa, I thank you all. Thank you.
Okay, so on behalf of the House, let me thank the ministers, to thank the members of the committee, especially this Committee on Legal and Parliamentary, has really had quite a big burden on their back to ensure that we have better laws. But I also want to thank the members who are always here to ensure that business is conducted in this house. And of course, I must thank the clerk and her team for assisting us to do our work. Thank you so much. Now, we shall not go to succession today. As you have indicated, there are things you still need to work out, and I'm sure the committee members are here. You work out when you can meet. Let's go to, there are some other items on the order paper which you can handle. For instance, item 8, I think it's for laying of a bill.
Item number 8, motion for reconsideration of the Landlord and Tenant Bill 2019 as returned by the President in accordance with Article 91, 3B of the Constitution and Rule 142 of the Rules of Procedure of Parliament.
Right, Honorable Speaker and Honorable Members, I beg to lay the bill, the Landlord and Tenant Act 2019 as returned by His Excellency the President to be reconsidered by Parliament. I beg to lay.
Now, members sent to the Committee of Physical Infrastructure for perusal and report back. And please do it urgently because time is of essence. Can we handle item 10? I don't know the coffee. The Agriculture Committee is ready with their report? The coffee bill? Yes.
Madam Chair, I submit, but I don't see my chair here. But what I'm aware is that the committee already handled that work.
So waiting for your report.
And the report is already appended to. It's already signed. I'm not sure whether it has been uploaded, but members have already signed on it.
But the chair is not here, and the vice chair. Okay, I'll let them to be here for tomorrow. Committee on National Economy, are they here for item 11? Okay. Can we also alert the chair of the Public Accounts Committee Local Government to be ready for tomorrow and item 12? Also item 13 should be ready for tomorrow. The chair of Committee on Trade, and then the item 14 should also be ready for tomorrow and item 15 as well. Because our people in the succession may not be ready in time. So I think we should just do the report.
Right Honourable Speaker, I'm here to present a report of the Committee on National Economy on the proposal by government to borrow up to Euro 69 million from Agence Française de Développement to finance the construction of water and sanitation infrastructure and associated activities in the district of Isingiro. Before I proceed to present the report, Madam Speaker, allow me to lay the following documents on table. What?
Chair, I think the minister, I've lost one of my ministers. I don't see the finance minister here for this, for this item. Huh? The Minister of Finance and the Minister for Water, they're both not here.
They are all not.
Because we may have issues we need answers.
Okay. So proceed?
No, I think let's wait for tomorrow and we'll notify them to be here. So I think the bulk of the remaining issues. Is Honorable Amede here for her motion? No? I think the rest are not here. So members, let me just thank you so much for the work done. House adjourned to tomorrow at 2 p.m.